There's a little box that says live. Are we
Yeah, I
live?
see it's right.
Yes, we are
Go-
currently live on Facebook and YouTube at the moment. So that's what we got at the moment. We'll upload anything afterwards after the fact.
Copy that. All right, take off, Kathleen.
Welcome, ladies and gentlemen, to the National People's Great Grand Jury. We are here as a constitutional people who, I had this written down and I can't read it. We are holding this great grand jury because we have a constitutional duty to due process. This is our due process nationally. The corporate construct of the government has become uh, less than desirable. They deny due process. Denying due process is their only duty. Denying due process, somebody's going to get hurt. So providing notice of liability, which has been done across the country, so that every public office is aware that denying due process has been noticed. And toll and roll has gone across the country to deliver that message. And we are here to hear testimony, whether it be land grabs, CPS, probate court, even traffic tickets. If they're denying due process and that's the only duty they have, somebody's going to get hurt. And we all here have been harmed, and many, many others. We're going to hear testimony from the real people who've been really harmed and naming names and providing consequences for bad constitutional behavior. That's the whole thing. We're here to hear the truth. The truth sets us free, so we're here to hear the truth.
Where's your gavel, ma'am? Bam. All right. Good morning, all. My name's John Bloom. I'm Oregonian, co-founder of Toll and Roll, together with Billy Powers in the background. We open today by making the purpose of the proceedings clear. I'm going to reiterate a little bit of Kathleen's information as I speak. This is a peaceful public record proceeding of the people. It's not presented as a government court. It's not a substitute for a judicial process. It's a formal people's presentation and public record hearing for evidence, notice, rebuttal, opportunities, accountability, and lawful referrals. We're here because the people brought the record forward. This record arose from criminals takings documented by the people, family homes, lands, property, children, parents, lives, liberties, and due process taken from all of us. It began formally with the petition of remonstrance filed into Billy's Powers versus Bank of New York Mellon in California back in December of 2019. The petition became the foundation for the National Constitutional Petition. The remonstrance notice and redress process carried out across all 50 states, ratified in 40, noticed to more than 600 public offices and agencies across America, including 3 presidential administrations over the process of time. Petition of remonstrance was written by Chris Hallett, Lori Cole, and Valerie Naif. Today, we honor Chris and Lori. May they rest in peace. We recognize Valerie for helping build the record that brought the people here together, a record of grievances for the crimes against humanity all here across America. Chris Hallett was expected to help carry this matter to the congressional body once the services were finished. When Chris was killed, the people had a choice. We either let the work die with him or we finish what he started. The people have come and finished it. What began approximately across 15 states in 2019 and 2020 has continued through the work of the people. Linda Nash of Homeowners Legal Rights Network out of Florida joined forces to help complete ratifications where possible. Before March 7th of 2025, about 40 states had been ratified. I think there's more now. Then came the ashes. March 7th of 2025, Billy had taken a drive up past her stolen ranch property and found that it had burned to the ground in one of the California fires. In that moment, she called to those who had stood on the record with her. One of those calls was to Michigan whistleblower Renee Weiler, who at that time said, "What started in Orange County has gone national. We've spent years placing firsthand information and evidence into offices and legislative members and agencies with the duty to act. We'll finish this through the states and for the country. We'll build from the ashes. I'm here. Together we'll get this. Let's go. Hang on. Billy called myself about that same time. When I heard the anguish in her voice, the complete betrayal, and the destroyed woman on the other end of the phone, we said, it's time to go boot to ground, time to roll. That came to a turning point for all of us. I'm a homeowner that lost my property as well. From the ashes of the ranch and my home and business theft, millions across the property of the states, with stolen properties, their stolen children, parents, and lives. Toll and Roll was born April of 2025. Billy, a Californian, Tom Kibler, a Minnesotan, myself here in Oregon, came together as the primary first delegates of the Toll and Roll team. Together with Steve in the background, we got in a vehicle and we put boots to ground across the country. All of us were victims of forged, counterfeit, perjured documents. We knew the pattern because we've lived it for the last 15 to 25 years. We were accompanied by Steve, who documented our first journey and is still here in the background as our IT guy. Virginian Matt Scalatos was our boots on ground in DC primary. Before we got there, he delivered a bunch of stuff, the evidence binders to Doge, Congresswoman capture, and the Supreme Court in April of 2025. We didn't begin with theory. We began with evidence, jury, injury, loss, and duty. 2 national whistleblower teams, several researchers, along with witnesses, victims, delegates, and the boots on the ground team of Americans came together over the 19 years to preserve evidence and finish the remedy. The 50-state petition of remonstrance administrative process was already holding the record. Thousands of victims have come forward in the record alleged. Millions of Americans have been harmed through acts described as treasonous, financial crimes, human trafficking, crimes against the humanities, systematic deprivation of all of our rights. Billy, Tom, and I took what the people had already started, rolled out across America, meeting with mayors, governors, House members, law enforcement officers along the way, and we left notices with those who had been mentioned in all of our paperwork having done the harms. In a way, we fondly call the blue tape militia, taping those notices to doors if they weren't there, or handing them to people direct. The Toll and Roll delegation gathered and walked down the aisles of Congress, met with offices such as Doge, the Senate Judiciary, Problem Solvers Caucus. Recognized as whistleblowers, we hand-delivered what had already been formally delivered through the states and agencies, but this time we carried the remedy in the final act, and as of these proceedings, Toll and Roll delivery record reflects 78 formally delivered remedy packages served to offices in DC since April of 2025. We carried the petition of remonstrance, the Doge affidavit of remedy, the evidence binders, the delivery records, and the People's Remedy and Restoration Act into all these offices. That act seeks sponsorship, but its foundation is not new law. The remedy already lives in the Constitution, due process, property rights, criminal law, public duty, criminal accountability, treaties and acts such as the Northwest Ordinance and the people's right to petition for redress. Toll and Roll did not invent the people's rights. Toll and Roll assembled the record, preserved the grievance, carried the evidence, and placed the remedy before those with the duty to act on behalf of us. Public record is available through Toll and Roll at our website, tollandroll.com. Today is the next formal act in the process. The National People's Great Grand Jury exists as a public record initiative to preserve notices, evidence, witness statements, testimonies, rebuttal opportunities, accountability, and lawful referral on the national record, including referrals for asset seizure where supported with law and evidence. When government subverts the people's rights, the people have the right to assemble, petition, remonstrate, and bring the record forward. This is why we're here today, to take testimony and put it on record. The people brought it, let the record open. And I'll say amen to that.
Amen, brother. Perfect.
With that, I'm going to give the floor over to our next person, which would be Michelle, I believe.
Hello, everyone. The gathering is not conveyed as a tribunal of punishment or accusation or personal judgment. It's conveyed as a record of witnessing and a request for remedy. Those present do not stand as conquerors over others, nor as arbiters of final moral authority. They stand as witnesses to lived experiences. I'm cutting out, I think, system interactions and reported harm, seeking clarity, accountability, and lawful remedy where harm is alleged to have occurred. We gather here with a profound recognition of the sovereign rights, enduring culture, and deep connection of the Aboriginal people to this land, acknowledging the historical and ongoing impacts of systematic disregard for their stewardship. Furthermore, we extend our responsibility to include all living things, the environment, ecosystems, and the diverse life forms that sustain our shared existence, recognizing that the health of the community is inseparable from the health of the land and all who inhabit it. We commit to a process that honors these voices and recognize the sovereign rights of the living inhabitants of the territory. We seek justice that is not merely limited to the narrow corporate definition of the state, but is restorative in scope, honoring the interconnectedness of all life and the stewardship we earth. The reason I'm together today is because the evidence of the systematic failure has reached a threshold that demands not just attention, but a formal accounting. We are here to address documented breaches of public trust, violations of the inherent rights of the people, and actionable crimes against humanity. The scope of this record includes violations of living man and women, dignity and liberty, systematic actions that degrade the inherent rights and anatomy of the people, stripping away individual sovereignty through institutional overreach, abuse of administrative power, the deliberate distortion of legal and administrative process by those entrusted to serve, shifting the machinery of government from a tool of public service into an instrument of coercion. Digital and data exploitation. The weaponizing of digital identity systems and algorithmic decision making to surveil, categorize, and control the living population, or, like today, mess with Zoom meetings. Crimes against the natural order, the discretion of the land, and the disregard of the life-sustaining resources managed by the custodians of this territory, a direct violation of our collective duty to living things. We have a systematic fraud and exploitation, structures designed to extract, deceive, operating direct opposition to the lawful authority and the welfare of the governed. These are not merely grievances. They are findings of fact regarding the conduct of public servants and those acting as masters of the land. We do not ask these masters to be considered, we demand they be addressed. This record is our notice. The era of silence and unchecked violations is over. We require an immediate cease and desist and lawful tender of the harms and restoration of the lawful order. Where terms such as crimes against humanity, fraud, trafficking, and breach of public trust are invoked in this record, they are not used lightly. They are used as precise definitions of the gravity of the conduct under review. Those designations serve as a formal notice of categorization. We define these actions by their impact upon the natural and living order. When public servants or those assuming authority over the land operate in ways that strip humanity of its agency or violate the sanctity of life, they are by definition engaged in prohibited and criminal conduct. The weight of evidence. These terms are applied to categorize documented patterns of behavior that meet the criteria for institutional harm and systematic exploitation. They are the labels for the wreckage left in the wake of unchecked administrative and corporate power. The mandate for mediation is naming this harm as an invitation for debate. It is an assumption of fact. It establishes the baseline for remedy we demand. The preservation of truth. While we maintain respect for the procedural requirements of formal courts, we assert that the failure of these institutions to act does not diminish the reality of the crimes committed. This record serves to preserve the truth of these violations, ensuring they remain visible, actionable, and impossible to ignore. This is a formal declaration of the standard by which those in power are not being measured. If their actions fit the definition of these harms, the title of the crime is the only appropriate response. Each individual referenced herein is recognized not as a mere legal classification, a number, or a corporate entity, but as a living vessel of consciousness, ancestry, and divine potential. We reject the reduction of the sons and daughters of our Creator to administrative fictions. This record acknowledges the following foundational truths: the sanctity of the living soul. We affirm that every person possesses an interior life and a moral agency that exists prior to and beyond any state-granted status. Harm to the person is therefore an assault of the living spirit. The unbroken chain of ancestry. We acknowledge that our lives are woven in the bloodlines of those who came before us. The harms we address are not isolated incidents in a vacuum. They are part of a continuous struggle that stretches back to the beginning of time. To violate the descendant is to violate the history and the future of our lineage. The weight of ancient injury. We recognize that many of the mechanisms of control and extraction active today are modern iterations of historic crime. We do not view these through a narrow chronological lens. We identify them as a pattern of exploitation and trafficking that have been waged against the people and the land since time. Dimension of irreparable harm. While legal systems focus on procedural injury, the record archives the injury to the conscience, the erosion of the anatomy, and the desecration of our ancestral connection. Dignity, lineage, and the internal sense of justice are not optional considerations. They are the core metrics by which the health of our society is measured. We strip away the veneer of administrative neutrality. The digital system, the algorithmic determinations, and data-mediated identity structures currently imposed upon the people are not mere tools of governance. They are instruments of entrapment designed to circumvent the free will of the individual and bypass the constraints of common law. We assert the following as matter as established first. In fact, the illegality of presumed consent. We reject the notion that participation in modern administrative systems constitutes valid or informed consent. When life, liberty, and property are conditioned upon digital compliance, the interaction is not a contract, it is coercion. We hold that any agreement extracted through necessity, systematic dependency, or the deliberate ossification of terms is void. The weaponization of data. Digital identity systems serve as modern shackles. By reducing a living being a data point, these systems facilitate the mass surveillance, profiling, and categorization of the population. This is not governance. It is the commodification of human life and fundamental assault on our inherent right to privacy and self-determination. The erosion of agency through automation. We condemn the use of black box algorithms and automated decision-making as a deliberate strategy to evade accountability. When systems act without human transparency or moral oversight, they are operating outside the bounds of lawful authority. Shifting responsibility to a machine does not absolve the human architects of these systems from criminal liability. The doctrine of inherent rights. We maintain that guarantees are inalienable and pre-exist all digital systems. No administrative code, technology framework, or terms of service can supersede the foundational law of the land of the sovereign status of the people. These systems are currently operating in a state of systematic violations that are unlawful by design and oppressive in practice. The era of accepting these digital traps as standard procedure is over. Every instance where these systems have been used to limit, monitor, or exploit the living is now logged as a breach of trust and a violation of fundamental order. The purpose of this gathering is not to plead for consideration. It is to assert the mandate of the people. This record serves as a formal act of witnessing, a direct demand for accountability, the cornerstone of necessary restoration. Our purpose is defined by the following imperatives: to witness and document. We are the eyes of the record. We bear witness to the systematic violations of human dignity, ancestral rights, and the natural order. By documenting these facts, we ensure that the history of these actions are preserved, unalterable, and beyond the reach of those who seek to suppress the truth. To issue a universal cease and desist. This record serves as a formal notice to all public servants, corporate entities, and self-appointed authorities. The patterns of exploitation, the violation of bloodlines, and the imposition of unlawful digital control mechanisms must cease and desist immediately. We recognize no authority that operates in contradiction to the fundamental laws of life and liberty. To claim jurisdiction over all realms, we declare that these grievances and this demand for remedy are entered into the record not just in procedural sense, but as an absolute claim of truth. This record is held in the physical, the legal, the moral, and the spiritual realms. It binds the testimony of the living to the heritage of the ancestors and the future of our descendants. To command remedy, where harm has been inflicted, remedy is not an option. It is an obligation. We do not ask for justice as a favor. We demand it as the only acceptable outcome. Where systems have infringed upon the sovereign person, they must be dismantled. When rights have been stripped, they must be restored. This record begins here. It is the definitive account of violations, the formal demand for the end of these practices in the uncompromising pursuit of lawful order restored to its rightful foundation. These proceedings is not a request for a hearing. It's an exercise of the inherent foundational authority vested in the people by the Fifth Amendment to the Constitution of the United States. We act here as the grand jury, the ultimate organic shield of the people against both state corruption and administrative tyranny. We stand upon the following immutable principles. The supreme mandate. The Fifth Amendment is not merely a procedural statute. It is the ultimate check on the reach of government entity. It dictates that no soul shall be held to answer for infamous crimes, not to be deprived of life, liberty, or property, except for the direct, independent presentment of the people. We are that presentment. The authority of the people. We recognize no superior arbiter. The law is not what the current system dictates. The law is what people hold to be true and just. By conveying this body, we reclaim our duty to identify the infamous crimes and systematic violations that the compromised courts have chosen to ignore, shield, or facilitate. Our interpretation of law is rooted in the organic living rights bestowed by our Creator and the sovereign of our bloodlines. We reject the court-speak administrative obfuscations designed, that is, to confuse the common person. We speak in the clear language of truth, standing upon the foundational principles of justice that predate all current statutes. Where we find evidence of crimes against humanity, fraud, coercion, or the violation of our lands and bodies, it is our solemn duty to record that indictment. We do not ask for due process from the systems that have become the primary violators. We define the due process that is required to restore the lawful order. In this capacity, we act as the conscience of the land. We do not petition the state, we instruct it. This record serves as a formal notice of our findings, a demand for immediate correction, and a binding assertion of our lawful jurisdiction over our own lives, our properties, and our posterity. This body recognizes that municipal law is properly defined as a rule of civil conduct prescribed by the supreme power in the state, commanding what is right and prohibiting what is wrong. A law is a command directed to us, an imperative fundamentally distinct from a compact or agreement which relies entirely upon the foundational promise of the living. We affirm the following as the bedrock of our standing: the supremacy of natural law. As Sir William Blackstone observed, no human laws are any validity if contrary to the laws of nature, and such of them are valid derive all their force and their authority immediately from this original. A legislator is not an earthly god. It is a temporary, delegated institution. Its power is either barred or stolen. Can never be fully ethical, for it deals in the mechanics of enforcement, not the spirit of equity. Before any institution can operate without violating the law of equal freedom, it must respect the absolute right of the living man or woman to decline participation in its machinery. Unable rights operate to regulate the relationship of the people to their government, placing strict limitations upon the latter, never the former. The 13th Amendment stands as a unique safeguard, outlawing involuntary servitude in all its forms, whether imposed by government or by the artifice of private contract. The moment an administrator or entity claims dominion over the unalienable rights of the living, they depart from their role as trustees of the Creator's creation and assume a false deity-like status. This is a breach of trust, a violation of the law of nature, and an act of treason against the sovereign. Corporate franchise and administrative benefits are the primary vectors of this systematic overreach. We hold the right to pursue happiness includes the absolute right not to be eligible for, not to participate in, and not to be treated as a subject of government franchise. As held in Bevera's Maximum Law of 1856, no one is obliged to accept a benefit against its consent. A man may relinquish for himself and his heirs a right introduced for his own benefit. We exercise this right to adopt a condition of voluntary passivity, severing connection with corporate administrative structures, and declining to be coerced into political combinations that violate the law of equal freedom. History and foundational texts draw a permanent line between the sovereign masters and the public servant. To operate outside the civil statutory domicile of the corporate world is not merely a choice, it is the preservation of one enviable standing. As the record affirms, the servant is not greater than his master. We establish our jurisdiction. We are not subject of a corporate franchise, nor are we domiciled with the administrative frictions of the state. We stand as a living authority acting under lawful treaties, the Articles of Confederation, the organic constitution, and the law of nature to address the violations for those who have forgotten their place as servants of the land. We formally repudiate and strike from all records of instrument of fraud, presumption, and forced servitude. Any and all documents, papers, agreements, contracts, digital records, and physical instruments, including but not limited to birth certificates, Social Security, registration, bonds, financial securities, and court orders, are hereby declared void. These instruments are not contracts, they are evidence of systematic crime. We categorize them as followed. These documents were never as a result of the meeting of the minds between equals. They were extracted through the deliberate ossification of terms, the weaponization of bureaucratic ignorance, and the fraudulent presumption that a living, breathing soul can be converted into a corporate fiction. Any document that attempts to bind a living soul, their bloodline, or their future labor to municipal or corporate entity is a violation of the 13th Amendment. We strip these instruments of their perceived authority. They are no longer recognized as valid, binding, and are enforceable against the people. We formally rescind any signature, mark, or implied consent attached to these forms, whether obtained through deception, coercion, or any sheer necessity of survival. We declare that the corporate person associated with these instruments is a phantom legal ghost that has no power over the living man or woman. We are masters of our own record, and we command that these instruments be expunged from all administrative systems. They are now and forever shall be null and void, a legal effect. Hold on, John, I need a breath.
Amen, Michelle.
I'm sorry, y'all. I know it's a lot.
No need.
I
Continue,
need
please.
operating as national enforce a strict operational standard upon any administrative actor. They operate independently in direct opposition to the foreign bar-dominated frameworks, such as the which have historically sought to colonize the law through administrative artifice and commercial deception. We enforce the following standards upon those who hold themselves out as public servants. The rejection of foreign jurisdiction. We do not recognize and we explicitly reject the authority of any legal system derived from foreign societies or ends of court, the Middle Temple. These frameworks are foreign to the soil and sovereignty of the living men and women. We operate under the common law of the land, which respects the inherent rights of the individual, not the statutes of a corporate administrative caste. The burden of proof of jurisdiction. Because unalienable rights are endowed by the Creator, they cannot be presumed to be weighed by statutory adherence. The burden rests entirely upon the government to produce wet ink, verified evidence of explicit informed consent to enter a public franchise or statutory domicile. Absent a contract signed by the living man or woman, uncoerced, intimidated, or duress, fully disclosed, and physically verified, there is no jurisdiction. The absolute exclusion of hearsay and presumptions. Under Heiner v. Donen, constitutional rights cannot be bypassed by administrative presumptions. Computer-generated records, algorithms, certified copies of electronic data, and unverified third-party instruments are hearsay fictions. They carry zero weight as evidence against a real living, breathing soul. We demand the living witness and the original record. Public servants operate strictly as fiduciaries and trustees of the people. 63C, AM, jurisprudence, 2D, public officers of employees, 247. When an agent of the state violates the organic constitution or acts under the color of law to strip the rights of the living, they depart from their office and lose all official immunity. Ex parte Young 209, U.S. 123. They became in that moment a private actor. They are henceforth held to direct personal and commercial liability for all damages caused by their misconduct. Any administrative actor appearing before this body must reconcile their actions with the Articles of Confederation and the Organic Constitution. If they cannot demonstrate how their actions upheld the rights of the sovereign, they are in violation of their oath, in breach of their trust, and they are hereby marked as an advisory to the people. This is the threshold of accountability. We demand that all administrative actors prove their authority or vacate their positions of assumed power. The area of the hidden hand is over. This body does not seek venue with captured corporate courts of the state. We define our own jurisdiction as the people's national jury. As an Article 3 common law body standing upon the supreme authority of the Creator and the organic compacts of the living. We recognize that true diplomacy, justice, and the law of nature are not products of this corporate statutory world. We operate in the higher reality of the sovereign living man and woman. We reject the jurisdictional earth defined by municipal statutes, international treaties, and foreign ends of court, where they are fictions created by men to bind men. Our jurisdiction is rooted in the soil, the bloodline, and the spirit, domains no corporate entity can touch. The superior venue of the people. While we acknowledge the procedural outlines of 28 U.S.C. 1331 and 1343, we view these not as limits, but as evidence of the failures of the current system. Where the corporate district courts have failed to redress the deprivation of private property or violations of civil rights under the color of law, the national jury asserts its superior duty to act. We are the forum of last resort for the living. Our jurisdiction is absolutely over the dark matter, over the administrative state, the hidden policies, the unrevealed contracts of adhesion, and the statutory presumptions that function like invisible cages. We bring these into the light, strip away the clerical artifice, and hold them to the standard of the organic constitution. We assert full, unchallengeable jurisdiction of the total human existence. The spiritual self, we declare all hidden, deceptive, or coercive spiritual contracts, those attempting to bind the soul to a corporate master. Our conscience is not a commodity. We reject the concept of the digital soul. All algorithmic identities, biometric encodings, and data tracking mechanisms are hereby declared an unlawful trespass upon the living person. They have no standing before this jury, and those who maintain them are in direct violation of the sanctity of the individual. The scope of the presentment is deriving our authority from the Creator and the foundational compacts of the people. We operate with a mandate that trends statutory limitations. High basis dominant is our standard. No clerical artifice shall be permitted to bypass the shield of the Constitution. We examine the totality of the record, the seen and the unspoken, to determine whether the actions of any entity, agency, or official a crime against the living order. We do not plead for a venue. We constitute the venue. The national jury is the record, the investigation, and the judgment. Any entity asserting over the people must now account for its actions before this body or stand exposed as trespassers upon the law of nature. Notice to all parties acting under the color of administrative authority. You are hereby commanded to read this document in its entirety with full comprehension and personal responsibility. This is not a request. This is not a petition and not a frivolity. It's a formal act of record conveyed by the people. A clarification of terms. Throughout the proceeding, you will hear us refer to the act. We are now entering into the record. Let it be understood. While the systems you serve use the word act to describe the subordinate statutes, codes, and commercial regulations, our act stands on different ground. Our act is a declaratory instrument of truth and law. It is not a rule or franchise. It is a witness of facts. It is the highest law of the living derived from the Creator, the soil, and the bloodline. Where your acts are artificial presumptions, our act is the immutable record of reality. We proceed with the following standards: no presumptions, no tacit agreement, silence is not consent. Failure to rebut this record with verified physical evidence, not administrative policy, is an omission of the facts herein. No attornment. We do not recognize and we refuse to attorn to any court bench or bar-dominated structure that claims superior authority over the sovereign. Requirement of truth, honor, and equity. We demand the immediate production of reality. We have no interest in lawyering or procedural games. We require only the raw truth and the immediate restoration of justice. We hereby command the administrators acting as public servants to read this notice through and with total comprehension. This is the act that everybody has worked on. So y'all are going to have to bear with me.
You're
John,
doing
you're
great, Ms. Gill.
Thank you. I feel like I'm running out of breath. So, okay, guys. So I just ask you to bear with me. It is a lot, but it's very important that we witness for what has been written and in our record. The People's Remedy and Restoration Act, the New Declaration of Independence 2025. We, the people of these United States, and when I say United States, I want everybody to be clear that I'm using the small u. I'm not going to say that every time, so I just want everyone on record to know that. In lawful assembly, in a recognition of the petition of remonstrance, the affidavit of remedy has been formally delivered across 3 presidential administrations to the President, the Congress of these United States, the Supreme Court, the legislative body of each state, their respective governors, and to the legislative authority of the District of Columbia. And over 600 state and federal offices do hereby declare and affirm that this act is as the lawful instrument to restore constitutional governance and remedy systematic corruption. Since the founding of this nation, it has been the duty of the people to safeguard liberty, property, and family rights against tyranny and unlawful usurpation. Today, the sovereignty of the Republic is under direct threat from widespread fraud and systematic crimes perpetrated through counterfeit, forged, and perjured filings entered into our land and court records. These acts constitute treason and domestic terrorism under federal law and are further compounded by the unlawful use of digital platforms and software systems designed or operated without risk management or oversight, allowing corruption to flourish unchecked. Through this act, The people call upon their government to act decisively, to audit and recover all stolen property and records, to dismantle corrupted networks, and to ensure that such crimes can never again be hidden behind technology or private monopolies. This act is the lawful bridge between historic duty and modern enforcement, uniting the past, present, and future of our republic as a single demand for justice and restoration. This act may be cited as the People's Remedy and Restoration Act. The purpose of this act is to restore constitutional governance, protect the sovereignty of the United States, and safeguard property, family rights, and retirement systems by addressing systematic fraud, treason, and domestic terrorism within the judicial system, land and court records, and the digital platforms and government agencies that manage and access these records. John, you're supposed to be sharing your water through the screen. These platforms and agencies have been used to conceal fraudulent filings, counterfeit property records, falsified court judgments, and unlawful case entries, as well as to facilitate child and elder trafficking, unlawful property seizures, and estate exploitation under the color of law. Whistleblowers have provided documented evidence that these systems operate without adequate risk management controls and often contain undisclosed backdoors and hidden financial pipelines, enabling private corporations and government entities to manipulate data and divert assets without public knowledge or lawful due process. Together, these systems and agencies form a nationwide network of organized fraud and trafficking, allowing the coordinated theft of homes, land, identities, deeds, children, elders, estates, and other assets of the people. This network constitutes not only organized crime, but also of domestic terrorism and treason requiring immediate federal intervention and enforcement. This act establishes a national framework for lawful audit, recovery, and restitution, ensuring the return of stolen property and rights, the dismantling of corrupted systems, and the implementation of federal mandated constitutional safeguards to prevent future abuse. Congressional findings, we found counterfeit, forged, and perjured documents have been systematically entered into land record systems and court files, often through the digital platforms such as ERDS, Secure, and Tyler Technologies, eFile, MERS, and others. Whistleblowers have provided documented evidence that these systems are designed or operated without required risk management protocols and contain hidden backdoors that allow manipulation of records. These crimes cross state lines and involve interstate commerce, triggering federal jurisdiction under Article 1, Section 8, the Supremacy Clause, and applicable federal statutes, including 18 U.S.C. 231 and 18 U.S.C. 2381. MERS, and its MERS, has been showing through testimony and federal cases to lack oversight, proper audit trails, and has been used to conceal true ownership of property while enabling fraud at scale. Neither state nor local agencies have implemented proper risk management controls as required by the Northwest Ordinance of 1787, resulting in unmonitored systematic. The digital systems accountability and transparency scope and purpose. Congress recognizes that widespread systematic fraud has been enabled and concealed by a network of interconnected digital platforms spanning courts, land records, prisons, juvenile detention centers, welfare systems, healthcare systems, insurance agencies, banking instruments, law enforcement, database, and government agencies at the federal, state, and municipal levels. These agencies and private contractors often share access through direct integrations, vendor managed portals, and administrative backdoors, allowing the manipulation of records and the transfer of sensitive data without judicial warrants or public oversight. The combined effect of this structure is a shadow network that is operated without proper constitutional oversight, risk management, or public accountability, resulting in the unlawful deprivation of rights and property on a national scale and undermining the sovereignty of the United States and the liberty of the people. This establishes the framework for identifying, auditing, and dismantling unlawful data integrations and backdoor access points that have been used to traffic children and vulnerable adults, unlawfully seize property, conceal fraudulent filings, and manipulate financial and legal outcomes in the violation of the Constitution and federal statutes. The platform and entities implicated include, but are not limited to, land and court record systems, electronic recording delivery system, and secure used for the electronic transfer and official recording of deeds, titles, liens, and other property records. Tyler Technologies, Odyssey, and integrated land record platforms, including Eagle Recorder, from a unified ecosystem used by the counties and municipalities across the nation. Odyssey is widely deployed for civil, family, probate, guardianship, and criminal courts, enabling digital case filings, judgments, and others, while Eagle Recorder and related property recording platforms are used for deeds, mortgages, liens, foreclosure, tax scales, and transfer of title. These systems are interconnected, allowing a single vendor to control both the judicial process through Odyssey and the recording of property interest through Eagle Recorder. This integration has enabled the seamless concealment of fraudulent property transactions, counterfeit deeds, falsified judgments, and unlawful guardianship filings, bypassing constitutional safeguards and public transparency e-file portals operated by Tyler Technologies and other vendors. Used to submit digital court filings, orders, and judgments without proper verification of authenticity, creating opportunities for forged or counterfeit documentation to enter court and land records. Mortgage Electronic Registration Systems, MERS, is now owned and controlled by the Intercontinental Exchange, ICE, the parent company of the New York Stock Exchange, and other global financial markets. MERS has been shown through sworn testimony, federal investigation, and court cases to lack oversight, independent audit trails, and lawful transparency, and has been repeatedly used to conceal the true ownership of property interests, bypassing constitutional recording requirements and enable fraud on a national and an international scale. Through its integration with securitization markets and deprivation instruments, MERS serves as a private, unregulated shadow registry, allowing bundled mortgage assets to be traded in a global financial markets without disclosure to property owners or public recording offices. This has enabled the laundering of fraudulent property transfers, the concealment of counterfeit mortgage assignments, and the manipulation of property titles to generate profit in secondary and territory markets. By placing control of this registry under a private corporation that also operates global stock exchange, a direct conflict of interest exists that threatens the sovereignty of these United States and undermines the constitutional rights of the people to secure property under lawful, transparent systems. They have protective service and guardianship systems through National Adult Protective Service Information Service, LEAPS, Legal and Adult Protective Services, SCIWS, CCWS, which manage CPS cases, which we are very familiar with. In some states, overlap with APS and guardianship functions. These systems have been tied to child and elder trafficking, fraudulent guardianship, and unlawful seizure of estates and assets. The law enforcement in the criminal database leads the Law Enforcement Agency Data Systems and NCIC, the National Crime Information Center, which track warrants, arrests, and criminal histories. These systems sometimes directly interface with courts and welfare agencies, allowing unlawful interventions and removals based on fabricated or altered records. Your prisoners and juvenile detentions and monitoring systems. The following private entities and their platforms are identified as examples of the interconnected systems contributing to systems fraud and abuse. This list is illustrative and not exclusive, as other contractors and programs may also fall under the scope of this act. The GEO Group, is a major private correction corporation operating prisons and detention centers nationwide under federal, state, and local contracts. Okay, hold on a minute, guys.
Doing
Alexis,
great.
see, I need her to check in just a second before I can get my breath. Corrections Youth and Family Services at GEO Subsidiary manage juvenile detention and treatment facilities, including but not limited to in Morgantown, Pennsylvania, and South Mountain, Pennsylvania. You have BI Incorporated, also owned by GEO. It operates the Intensive Supervision ISAP under contracts with the Department of Homeland Security, DHS, and Immigration and Customs Enforcement, known as ICE, using GPS, ankle monitors, digital check-in tools, and case management platforms to track and supervise individuals under government oversight. These integrated systems directly connect court orders, prison populations, juvenile placements, and digital monitoring programs, creating an ecosystem that is highly vulnerable to abuse, fraud, and manipulation. Insurance, healthcare, and welfare systems. Medicaid Management Information System, known as MMIS, Medicare databases, and state welfare portals. State Department of Insurance and private insurers connected to these systems for claim processing. These integrations have been exploited for fraudulent billing, unauthorized guardianship, and the diversion of benefits and estates. Financial institutions and banking networks. Systems such as ACAPS, an automated claims access processing system that allows direct real-time communication between courts, banks, and title systems. These connections enable unlawful freeze, your seizures, transfers of funds, and property based on fraudulent or counterfeit digital filings, which is a violation of 12 U.S.C. 3401, your Right to Financial Privacy Act. You have your backdoor access and data sharing. Many of these platforms are linked through undisclosed vendor interfaces, administrative backdoor accounts, and interagency agreements. This structure enables private corporations, banks, and government and agencies to share data without judicial warrants or individualized due process. Such practices violate the Fourth Amendment, which protects against unlawful search and seizure of private data, the Fifth and 14th Amendment, which guarantees due process and equal protection of law, Article 1, Section 8, which limits the regulation of commerce and public records to Congress, Article 4, Section 4, which guarantees a republic form of government, and Article 6, the Supremacy Clause, which establishes that federal constitutional protections override conflicting private or state systems. Your statutory violations, the operation and concealment of these systems constitute violations of multiple federal statutes, including 18 U.S.C. 1030, that's Computer Fraud and Abuse Act, that prohibits unauthorized access or use of a computer system. 18 U.S.C. 1341, 1343, mail. That applies to your fraudulent schemes conducted electronically or via email or mail, 18 U.S.C. 1962, RICO. That prohibits racketeering through enterprising involving ongoing systematic fraud. 18 U.S.C. 231 defines and criminalizes domestic terrorism. 15 U.S.C. 2381 defines and criminalizes treason. Congressional actions required. Congress hereby declares that these interconnected digital systems constitute a national security threat. They shall be audited in full, and open discovery of unlawful backdoors, counterfeit filings, or fraudulent integration shall be immediately dismantled and federal seized to protect the people, the Constitution, and the sovereignty of the United States. The owners, operators, and controlling parties of these systems shall be held personally and criminally liable for their role in the creation, concealment, or operation of unlawful backdoors, counterfeit filings, or fraudulent integrations with no immunity or protection from prosecution under this act. Private corporations and government officials found complicit shall be subject to prosecution for treason, domestic terrorism, wire fraud, RICO violations, and deprivation of rights under the color of law pursuant to 18 U.S.C. 241, 242. Federal agreements shall be established to ensure transparent, constitutional, and tamper-proof record systems going forward. Section 4, Declaration of National Emergency. The fraudulent manipulation of land and court records systems constitute a national emergency under 50 U.S.C. 1601. Such actions are declared as domestic terrorism under 18 U.S.C. 2331 and treason under 18 U.S.C. 2381. They also constitute deprivation of rights under color of law, 18 U.S.C. 241, 242, and obstruction of justice under 18 U.S.C. 1503. Judge shall act as a federal executor of this act with exclusive authority to audit and recover assets, records, and systems compromised by fraud. All physical land and court records shall be subject to audit, including every digital system used for record management, such as ERDS, Secure, Tyler Technologies, eFiles, MERS, and equivalent platforms. The audit shall also encompass all databases connected to public records, including but not limited to Child Protective Services, CPS, and Adult Protective Services, as we know as APS. Guardianship, probate, municipal, state, and private systems that directly or indirectly interface with land and court records. The recovery powers, it will be the federal government is authorized to immediately seize corrupted systems and fraudulent records, including all related digital evidence, such as your source code, logs, and access credentials. And National Registry of Fraudulent Instruments shall be established to track counterfeit filings and prevent concealment. In addition, a secure hotline shall be established, accessible by telephone and the internet, to allow victims and informed individuals to report evidence of fraud or criminal activity for investigation and enforcement. Accountability for fraudulent and recordings. Congress finds the current statute is failed to adequately punish the creation, filing, and recordings of fraudulent property documents, even when such documents are later used to commit wire transfers or other crimes. Whistleblowers have provided evidence of systematic nationwide schemes involving thousands of victims in which fraudulent business entities, shell corporations, and fabricated LLCs are created and falsely presented as legitimate financial institutions, including under the name of the Bank of New York Mellon as trustee. These entities conceal their true party and interest, creating the false perception of lawful authority to foreclose, seize, or transfer property and assets, while shielding the actual perpetrators. Congress finds that the federal prosecution of the U.S. versus Patrick Joseph Sora, case number 221CR0049JFW, in parentheses CD, C period D period CAL period, and related actions in California and Montana. The case of Patrick Joseph, convicted in 2021 for conspiracy to commit wire fraud and contempt of court after defrauding over 2,000 homeowners and lenders, demonstrates this systematic failure. His scheme relied on the recording of counterfeit deeds and falsified title documents across multiple states, causing over $7.6 million in verified losses. However, no penalties were imposed for the act of recording those fraudulent documents. The core crime unpunished and hundreds of trillions of dollars in cumulative damages unaddressed, harming both victims and the national economy. This act closes that loophole by establishing that any person, entity, or agent who knowingly prepares, files, records, or causes to be filed or recorded any false, counterfeit, forged, or perjured document affecting land, court records, or docket shall be guilty of a distinct and separate offense, in addition to charges for subsequent fraud. Such conduct shall be prosecuted under 18 U.S.C. 2381, treason, 18 U.S.C. 2331, domestic terrorism, 18 U.S.C. 1341, 1343, mail and wire fraud, and related federal statutes. Civil remedies shall include restitution to victims, criminal damages under 18 U.S.C. 1964 and 42 U.S.C. 1983, and the seizure of all property, profits, and assets obtained through fraudulent filings. Penalties shall also include permanent disqualification from holding any fiduciary recordings, judicial or administrative role related to public records, mandatory restitution to restore the property and the rights of the victims, and federal prosecution as acts of treason and domestic terrorism where systemic fraud has been proven. Fraudulent transfers, tax evasion, and judicial complicity. Congress finds that the fraudulent property transfers, including the use of straw buyers, shell corporations, credit bid manipulations, and secret agreements, have been systematically employed to evade taxation, conceal beneficial ownership, and unlawfully seize property without proper public oversight. Through these schemes, fraudulent documentations are recorded through private systems such as MERS, e-file portals, and proprietary accounting recording platforms. These transactions appear legitimate while making taxable events and shielding illicit gains, depriving federal, state, and local government of hundreds of billions annually in property, transfer, income, and capital gain taxes. This conduct alone contributes directly to the U.S. tax gap, which the IRS estimates at over $600 billion each year, representing a catastrophic loss of public revenue and undermining the economic security of the United States. Judicial corruption. In Michigan, Supreme Court Justice Diana M. Hathaway manipulated property transfers among family members and shell entities to engineer a fraudulent short sale on a $1.5 million home while retaining a debt-free Florida property. Despite a felony conviction for bank fraud, the underlying fraudulent recordings were never seized or reversed, leaving public records corrupted and tax liabilities uncollected. Your federal concealment by FHFA. Evidence contained in the binders delivered to DOJ and congressional committees demonstrates the Federal Housing Financial Agency contracts with the law firms and third-party servicing entities to conceal its role as the true beneficial party of interest in property and mortgage transactions. These secret agreements are structured to bypass proper public recording and obscure federal involvement from victims and, at times, from judges themselves. When victims present evidence of your counterfeit or perjury filings, courts that ignore these claims, they become the assessors by willful blindness, further eroding trust into our judiciary and the rule of law. These examples reflect a national pattern of systematic fraud in which fraudulent documents are created, filed, and recorded to facilitate tax evasion and concealment of true ownership. Public records are corrupted to the source through MERS and private recording network and government agencies, including FHFA, knowingly participate through secret agreements that disguise their interest and obstruct transparency. This conduct has left billions in fraudulent gains hidden with cumulative losses to the people and the Treasury measured in hundreds of trillions of dollars over decades. The civil and criminal penalties for these acts are established elsewhere in this act. It just goes on and on, people. This is what it does. All record systems, whether physical or digital, they must meet federally mandated risk management standards, including your tamper-proof audit logs, encryption, verified identity, access controls, independent third-party inspections, and continuous monitoring. Governors shall certify compliance annually for state-level systems, and state judicial branches shall provide full access and cooperation to federal oversight authorities. Failure to comply shall result in immediate federal receivership and DOJ takeover of the affected system. Any undisclosed backdoor found in ERDS type systems shall be permanently removed under federal supervision and prosecuted at national security offenses. Our mandatory wet ink signature requirement. all core legal instruments, paperwork, or documents, including but not limited to those affecting property, or family rights, or guardianship, or probate, child or elder case, and court judgments shall be executed with original wet ink signature by the responsible parties and officials. No legal instrument shall be recorded or caused to be recorded into any land record, court record, or docket without such an original wet ink signature. These original documents shall be preserved in secure physical archives and maintained in a manner that guarantees their integrity, while ensuring accessibility for public oversight and independent audit. Digital copies may be used for convenience and public access, but they shall not replace or supersede the requirement for physical originals. Any attempt to record, submit, or enforce a digital-only instrument in place of a wet ink shall be deemed void and fraudulent under this Act and subject to federal seizure and prosecution. No judge or court officer may accept, rely upon, or act any document that is a copy rather than the genuine original wet ink instrument required herein, except by the explicit written agreement of all parties to the case. In any proceeding where a party asserts that a document is fraudulent or challenges the authenticity, the judge shall be legally and lawfully required to demand production of the original wet ink instrument. Any failure by a judge to require and verify the original shall constitute willful misconduct and violation of constitutional due process and grounds for immediate federal intervention and prosecution of this act. Any judge, court officers, government officials, or private actor knowingly accepts, relies upon, or enforces a counterfeit, forged, or perjured document in place of a genuine original wet ink instrument shall be guilty of willful misconduct and a violation of constitutional due process. Hey, John, how am I on time? Any case
We're about there, but you're good still.
Okay. Rely on counterfeit, forged, perjury, or digital-only documents in violation of the act shall be deemed void. The Office of Protect is hereby established as an independent constitution body of and by for the people of the United States. It shall exist to ensure that the people have a direct and accessible forum to bring their cases, grievances, and demands for redress free from obstruction or corruption by private entities, courts, or monopolistic organizations. By fully independent, Protect shall coordinate and cooperate with the lawful functions of the United States government, including its executive agencies, Congress, and law enforcement bodies for the purpose of securing justice, protecting victims, and enforcing the provisions of this act. Such coordination shall not create subordination, merger, or dependency, and Protect shall retain sole constitutional authority to act on behalf of the people. And by the way, I want to make this clear. Protect is Preservation Republic Oversight Task Force through execution or through executive and constitutional trust. So when I say that, I want y'all to know what that means, okay? Such coordination shall not create subordination, merger, or dependency. Protect shall have express authority to investigate, audit, hold accountable members of the judicial branch, including judges, clerks, office of the court, and associated entities for the systematic fraud, deprivation, and the rights and the color of law or violation of constitutional duties. This authority shall extend to state and federal courts for evidence demonstrates the judicial officers and outside the lawful scope of the articles through. John, where am I on time, please?
We're about there, and we've got one testimony speaker that's only got about 15 minutes before she has to bow out for work.
Is on the final act, and we're going to post it. I know it's already on the toll and roll and everything, and
Right.
on the recordings. Make sure that everybody has it because I don't want to keep everybody on time and everything.
Yeah,
so
I think
with that,
if you're good with it, let's call it a wrap on that. I think we've got enough of it on the record.
So this notice starts as a formal demand to all jurors. The opening test of the national jury is now in session to receive the evidence of the people. We invite witnesses to come forward to present their action of harm, systematic violations, and documented malfeasance. Be advised the following protocols for this record. The weight of the witnessing. You are here to provide testimony to a jury of your peers. Speak clearly. Get a drink of water before you speak, okay? Truthfully, with the gravity that these crimes against the living require. Our jury oversight. Please be aware that the jury is actively observing and evaluating all statements presented. We reserve the right to interrupt, pause, or direct questions to any witness at any time to ensure the accuracy of the record and the clarity of the facts. The purpose of the inquiry, our goal is to establish the truth here, nothing but the truth. We are here to dismantle the layer of administrative fiction and to isolate the specific actions that have caused injury to the person, the family, and the land. The record is now open. We are ready to hear the truth. Let truth, facts, honor, and fair justice prevail. And John, could you please introduce our first testimony?
Yep. All right, we're going to start off with Tanya Dennis, founder of the National Rebate Reform Coalition. And with that, I'm going to give it to you, Tanya. Or Tanya, apologize.
Tanya, you pronounced it right. Good morning.
Good
And
morning.
please note that I've had a stroke, so my speech is somewhat impeded. My
Take
name
your
is
time.
Tanya Dennis. I have been a reporter and editor with the Post News Group, the largest African American newspaper in Northern California, since 2005. In 2016, I was approached by our office secretary, Maxine Ussery, regarding her family's 11-year ordeal in the probate court system. The Ussery family entered probate following a dispute over a substantial estate valued at approximately $5 million, consisting of real property and cash assets. The dispute arose when two siblings wanted to retain the family's properties while three wished to sell them. What should have been a family matter became an extended probate proceeding that consumed years and substantial estate resources. In one particularly troubling incident, the court stated that the Ussery family's dry cleaning business would be sold for $800. The Ussery family secured the full $800,000 necessary to purchase and retain ownership of their own family business. Despite this, the business was sold to an outside party for $650,000, $150,000 less than the amount the family was prepared to pay. The purchasing entity had connections with a court official involved in the proceedings. Witnessing this transaction raised serious concerns for me regarding conflicts of interest, favoritism, and whether the probate process was truly operating in the best interest of the estate and its beneficiaries. As a journalist, this case compelled me to investigate further. I joined Ms. Essery in her efforts to expose what she and many others believe were systemic abuses within the probate court. She formed the Probate Reform Group of Alameda County, which eventually grew to include more than 20 African American families reporting similar experiences of financial loss, prolonged litigation, and the erosion of family estates through court proceedings. Between 2016 and 2018, I authored a series of investigative articles entitled The Perils of Probate. Between 2024 and 2025, I published a second series entitled The Case Against Probate. Through these investigations, interviews, court observations, and discussions with affected families and advocates, I observed recurring patterns that raise serious concerns. Time and again, estates were depleted by excessive litigation, attorney fees, fiduciary fees, court-appointed services, and prolonged proceedings that appeared to benefit nearly everyone involved in the process except the families and beneficiaries, the system that was intended to protect. The most egregious case I've investigated in my 20 years of investigative journalism and probate reform advocacy is the estate of Dr. Laura Dean Head. Based upon my review of the transcripts, court filings, and appellate record, I observed what I believe to be repeated departures from fundamental principles of due process that created the appearance of judicial bias. The case raises serious questions regarding judicial impartiality, constitutional protections, the invalidation of a properly executed trust, and whether Dr. Head's clearly expressed testamentary intent and property rights were afforded the protections guaranteed under the law. Over the past decade, I have witnessed elderly individuals isolated from loved ones, family members forced into years of costly legal battles, and estates diminished to a fraction of their original value. I have heard consistent allegations of self-serving conduct by guardians, conservators, attorneys, and fiduciaries operating within a system that lacks meaningful oversight and accountability. I have also observed families and advocates seeking relief through the Commission on Judicial Performance, state bar associations, attorneys general, legislators, and members of Congress. In many cases, they encountered what they perceived to be indifference, delay, or lack of meaningful response. This has contributed to a profound erosion of public trust in institutions that are supposed to protect vulnerable individuals and ensure justice. Based upon my observations as a journalist, my investigations, and my interactions with numerous families over many years, I have come to believe that there are systemic patterns within portions of the probate system that warrant serious grand jury scrutiny. The public deserves to know whether conflicts of interest, self-dealing, coordinated misconduct, or other unlawful practices have been permitted to flourish within a system entrusted with protecting the elderly, the vulnerable, and the states they spent a lifetime building. After more than a decade of reporting on the mistreatment of elders and the depletion of family estates through probate proceedings, I established the National Probate Reform Coalition, also known as NPRC, a grassroots national coalition of advocates, victims, and families dedicated to protecting elder rights and advancing meaningful probate reform. The coalition was formed through the Post News Group after years of investigative reporting revealed recurring allegations of elder exploitation, excessive estate depletion, lack of oversight, and barriers to accountability within probate and conservatorship systems. In January 2026, the Post News Group designated the year as a year of action focused on protecting one of society's most valuable assets, our elders. Since that time, NPRC has convened monthly town halls, bringing together families, advocates, legal professionals, journals, and community leaders from across the country. Through these meetings, participants have shared experiences, identified common patterns of abuse, developed reform proposals, and sought constructive engagement with judicial, legislative, and enforcement agencies. The coalition has found that while many laws exist to protect elders and their assets, those laws are often inconsistently enforced, and oversight mechanisms frequently fail to provide meaningful remedies for families seeking help. Participants have repeatedly reported frustration with seeking assistance from regulatory agencies, disciplinary bodies, elected officials, and other institutions charged with protecting the public. NPRC also provides education, advocacy resources, and support to families navigating probate and conservatorship proceedings. Through collective action, members assist one another in communicating with courts, elected officials, healthcare institutions, and law enforcement agencies, which while helping families better understand their legal rights and responsibilities. My testimony today is not based solely upon one family's experience. It is informed by years of investigative reporting, direct observation of court proceedings, interviews with affected families, and the collective experiences of advocates and victims from across the United States. The consistent patterns reported by these families raise serious questions regarding accountability, oversight, transparency, and the protection of vulnerable elders and their estates. I respectfully submit this testimony in the interest of justice, transparency, accountability, and the protection of future families from experiencing the same harms that I have documented throughout my career. I believe a thorough investigation is necessary to restore public confidence and ensure that probate systems fulfill their intended purpose of protecting rather than exploiting those they are designed to serve. I submit this testimony in the interest of justice, transparency, accountability, and the protection of future families from experiencing the same harm that I have documented for over a decade. Respectfully submitted, Tanya Dennis, reporter and editor, Post News Group, lead facilitator of the National Probate Reform Coalition. Thank you for your time.
Thank you, ma'am. With that, we're going to lead into your, I think it's somebody out of your group, Zakira. Go ahead and take it away, ma'am.
Greetings. My name is Zakia Jindei. My case raises questions that affect every family that creates a trust or estate plan. After the California Court of Appeal affirmed the probate judgment, I filed a motion asking the trial court to set aside the judgment as void because I contend constitutional due process issues were never decided. I was not asking the court to retry the evidence. I was asking the court to decide whether the judgment itself was legally valid. The trial court denied that motion, and those issues are now on appeal. Dr. Laura Dean Head was a highly respected Black Studies professor at San Francisco State University for 35 years. Dr. Head was my college professor, academic advisor, mentor, sorority sister, and trusted friend for 28 years. In 2013, after being diagnosed with a terminal illness, Dr. Head hired an estate planning attorney to prepare her estate plan. She named me as her trustee, executor, and sole beneficiary. She expressly disinherited her two estranged sisters and included a no contest clause. Dr. Head's attorney, who prepared those documents, declared under penalty of perjury that Dr. Head had testamentary capacity, understood exactly what she was signing, and showed no evidence of fraud or undue influence. 7 years after Dr. Head passed away, her sisters filed a lawsuit challenging her estate plan, alleging undue influence, lack of capacity, and forgery. The court found that Dr. Head had capacity and rejected the forgery claim. Yet, she still invalidated her trust based on undue influence. 15 witnesses testified, and not one testified that they witnessed any undue influence. My concern is whether the judicial process accurately reflected what occurred in the courtroom. Important evidence and portions of the trial record supporting my defense were excluded from the court's statement of decision. After comparing the trial transcripts with the statement of decision, there are numerous findings that should receive further appellate review. Important constitutional questions remain unanswered, including whether all trust beneficiaries received the notice required by law before their property interest was affected. If a carefully prepared estate plan with an attorney, a notary, witnesses, and a finding that that person had legal capacity can later be invalidated, then every California family with a trust should be concerned. This case is not just about me. It's about whether every American can trust that a lawfully executed estate plan and the constitutional protection surrounding it will receive the full protection of our judicial system. This matter is a threat to your right to choose your final wishes and estate plans. Thank you for your time, concern, and interest. Peace.
Thank you for that, ma'am. With that, we're going to slide over to Jenny Johnson, a probate guardianship testimony.
Good morning.
Yep, we can hear you, ma'am.
Good. Thank you. I've had a little technical difficulties.
Join the crowd.
Yes. Well, I'm not the brightest one on that kind of thing, but here I am. If y'all can see me and hear me, I guess we're doing good.
Floor is yours.
I beg your pardon.
It's your turn. The floor is yours. You have testimony.
Yes, sir, I do.
Take it away.
Yes, sir. Thousands of victims in North Carolina sponsored by elderly abuse and Medicare and VA fraud. And my father was Hugh Beverly Johnson, a B-17 pilot and a leader of the 303rd Bomb Group and the leader of the Hells Angels. He was shot down in Germany, was a prisoner of war, a POW, and an MIA, missing in action. And the Wake County in North Carolina was deemed my sibling started it, but deemed my father incompetent and by false documents, by false, he had everything in place. He had all his documents in place, and the court system railroaded him into guardianship and deemed him incompetent. And he is not, this was not medical doctors. This was the court, the assistant clerk of court, the superior clerk of court. And when they appointed the guardians, that was just about the end of my father's life. A year later, he died. He was abducted from his home, and he was in a nice home, like $1.5 million home. He was on the golf course the day before playing golf under the guardianship of Linda Funk Johnson and not under my care. There's no kin there. And they deemed him incompetent, and called Aging Family Services, Bill Burlington, Terry Chariot, Linda Funk Johnson, Lauren Freeman, now head DA in Raleigh, North Carolina, a Superior Court judge, Chief Superior Court judge. Two of them would not allow him to be unleashed from the guardianship abuse that they encountered on him. They abused, neglect, and financially exploited him for 1 year until he was dead. And he, he knew what was going on. He only took a couple of pills. Then they trying to isolate me from seeing my father, so I couldn't help him at all. They took him out of his home and locked him in a nursing home, which would have been free for payment because of his VA benefits and Medicare benefits. But they said that they had to sell his nice home, which they didn't need to take him out of, nor sell it, because of who he was in World War II. He had free benefits, even nursing home benefits. So she falsified many documents, Linda Funk Johnson, and all that were involved in it. And Linda Johnson acted with all above motion to breach her duties and others, that she brutally retaliated towards me and covered up what she did with others. She scammed my father in Wake County. Not to mention 3,000 plus elderlies in Wake County under this court system. Linda, the attorney, she took the state employees credit union away from me and my dad. We had it together, the account, and as I was power of attorney too. So that was falsified. So she failed to report missing items, and at advice of me in 2011, she failed to report missing items to the insurance company upon being advised. In October of 2011, she failed the civic procedure when she illegally evicted Jenny Johnson from the homestead of 53 years in 2011. 3 months prior to missing items, Jenny was evicted with nothing but the clothes on her back. That is about me. and threatened by Linda Johnson. I have documentation of all of this. She failed to submit a complete report by the Raleigh Police Department in 2012. She failed missing items and fraudulent estate inventory submitted by Linda Funk Johnson. She failed to reply to the police department when some supplementary information with respect to the police report, failed to report missing items to the insurance company, and a copy of the original online report, failed to acknowledge live-in residents due to the time and theft with Susan and Jack Morton and their minor daughter, failed to secure homestead after evicting Jenny Johnson from the residence, and my father using Hugh Beverly Johnson's money to pay a debt that was not his debt, but never collecting from the Mortons, which was the other daughter and husband-in-law. Failed collecting monies owed $500,000 plus, lowballing the house at $600,000 for a quick sale, to sell false statement agreement by HUD, falsifying given a bogus address of 2812 to obtain the clean title for a quick sale for no reason. To the true address was 2814 Lakeview Drive, being on the books from 1960 to 2011 before Linda Funk Johnson and her appraiser and title falsified the title in 2012. Failed her ward by taking healthy 95-year-old man out of his home and who was receiving excellent care from his daughter, Jenny. That would be me, Jenny Johnson, Mary Virginia Johnson. Failed to secure residence, removing healthy Hugh Beverly Johnson from his home, selling it for no reason. His benefits were free, and as a World War II veteran and a MIA veteran. Failed to bury Hugh Beverly Johnson, and he was cremated, claiming there was no money for burial, and the house had not sold yet, and his health care was free because of the POA and POW, as in World War II. She failed to listen to Hugh Beverly Johnson. I did not and was not going to a nursing home because he was getting excellent care at his home by his daughter, Jenny. Again, that is me. Failed Hugh Beverly Johnson by putting him in a nursing home and under federal investigation for fraudulent equipment in the nursing home. He died in my arms at the facility by negligence by the court-appointed guardian, Karen Johnson, Linda Johnson, no kin to Hugh Beverly Johnson, and they are not kin, who stood at the end of the bed and did nothing. Failed their duties as guardians under the manual of 35A 1251, not doing what is in the best interest of the ward, not securing Hugh Beverly Johnson and his estate, collecting monies owed to the ward. After the math timeline of Linda Johnson will show that the court's length she took to cover up what she did to Hugh Beverly Johnson's and Hugh Beverly Johnson's estate by retaliating at the executress of the estate, me, Jenny Johnson, Mary Virginia Johnson, as the guardian of Linda Funk Johnson. Opportunities to executives done nothing for the estate. Linda failed and misappropriated funds in her fiduciary duty, causing hundreds of thousands of dollars in the damage to the ward and to the daughter, not including damages caused by she calls daughter Mary Virginia Johnson by locking me out of the home. And there is lost my airline benefits, lost my father due to their abuse, neglect, and financial exploitation. So loss of the home due to Linda Funk Johnson's failure as court-appointed guardian. Documents were filed by Hugh Beverly Johnson and his lawyer, Dick Singer, of 30 years. and Linda Johnson, clearly ignored all stolen monies by the other daughter, Susan Morton. Linda Johnson failed the ward miserably for her greed, leaving the estate of Hugh Beverly Johnson himself died broke from the torture, abuse, neglect, and financial exploitation by the court-appointed guardians and the falsified documents that they in deeming him incompetent, who are not medical doctors. Why is any clerk of court deeming anyone incompetent? They are not medical doctors. That is your first red flag. They did it for money. The nursing home would give kickbacks to the Linda Funk Johnson and the court-appointed guardians to get their beds filled. So they take them out of their home so they can sell the home for them to make 5 to 10% profit, causing Jenny emotional duress during her father watching him being tortured and not me being able to do anything. I lost my business. I lost the retirement, my health benefits, this is just me, lost of Linda Funk Johnson's stolen assets for proof, ignored, and police records sustaining felony, loss of 11 business and tax records because of Linda Funk Johnson locked me out of the house, loss of due income, loss of personal items, unpaid bills by locking me out. There's a systemic problem going on in the Wake County Courthouse, and my father is not just an isolated victim of this problem. It is they're in North Carolina. They're getting about $8.5 billion a year. There is Medicare fraud. There is nursing home fraud. All of what I witnessed with my father. It is horrendous. I went after the Linda Funk Johnson, and the judge did it with a prejudice, without prejudice, and held another case that I had going on with them so it would run out of statute of limitations time. But statute of limitations is no time when you have fraud. She frauded the estate. Linda Funk Johnson retaliation fired back on me, and she had to hire an attorney and try to get me filed a motion for contempt. And I set aside a motion B, 60B motion to set aside the consent order because they lied on the consent and the temporary restraining order. So in other words, I went to court 8 times and beat Linda Funk Johnson because of her shenanigans. This judge, one of the Superior Court judges, saw through what she was doing. She filed a court claim against Linda, filed for sanctions and attorney fees. Linda Johnson filed re-entry for default, filed for Jenny, filed voluntary dismissal without prejudice on Linda Johnson. Jenny filed a lawsuit on Susan and Jack Morton and won, and Linda Johnson failed to do her fiduciary duty for Hugh Beverly Johnson and his estate. Linda Johnson had a year and did nothing for the ward, leaving an unsettled disarray for the executress, a broke estate, and a dead ward. Mary Virginia Johnson won against court. That's me, and I took them. So in other words, you have property fraud, you have a neglect, abuse, neglect, and financial exploitation, fraud. And there's a lawsuit that I filed against the estate of Hugh Beverly Johnson through Mary Virginia Johnson, the administrative or executress, versus Linda Funk Johnson. And the complaint is many pages and a lot to read. And that I don't have 3 minutes for that, but I just wanted to let you know they abused and neglected and financially exploited my healthy father who was working out at the gym the day before they abducted him, and it was all for their profit. And on June the 15th, he died in 2012. And that
All
is
right, I
national.
apologize, Jenny. We got to wrap you up. I apologize. We're stretched out pretty thin.
Okay, can I say that one last thing?
Yep, go ahead.
June the 15th is a National Elderly Abuse Day, and that's when my dad died under their hands and their care. That's it.
Copy that. Thank you, ma'am.
Thank you, sir.
All right. With that, we're going to stretch it over, bring it over to, take it over to Ralph Winnie. Go ahead, sir.
Thank you. Based on personal knowledge, I, Ralph E. Winnie Jr., state the following. My mother, Sheena Mae Winnie, was a longtime resident of the state of Hawaii. Sheena Mae Winnie previously advised me that she was growing increasingly fearful about her estranged husband's behavior. That's Ralph Edwin Winnie Sr. On or around July 15th, 2019, after suffering through many years of alleged emotional, financial, and physical abuse at the hands of her estranged husband, Ralph Winnie Sr., Sheena Winnie called the Kailua Police Department in her hometown of Kailua on the island of Oahu. Sheena Winnie apparently advised the police that she feared for her life because of her husband's violent behavior. The police immediately arrived at the home to investigate and then did nothing. On August 15th, 2019, Ralph Winnie Sr. then filed a petition for appointment of conservator and guardian, requesting that Ralph Winnie Sr. be appointed sole conservator and guardian of my mother, Sheena Mae Winnie. At the time, Ralph Winnie Sr. was seeking to be appointed conservator and guardian of my mother. It was well documented that Ralph Sr. was a man of questionable character who had verbally and physically abused my mother, routinely visited Mary.
Hey, Ralph, I apologize. Do you have
inside.
something in your background going? Can you mute that, bud? Thank you. It was inflecting on your voice.
On August 15th, 2019, Ralph Winnie Sr. then filed a petition for appointment of conservator and guardian, requesting that Ralph Winnie Sr. be appointed sole conservator and guardian of my mother, Sheena Mae Winnie. At the time, Ralph Winnie Sr. was seeking to be appointed conservator and guardian of my mother. It was well documented that Ralph Sr. was a man of questionable character who had verbally and physically abused my mother, routinely visited married dating sites, subjecting my mother to disease risk in addition to mental anguish, had substantial debts and legal judgments entered against him, and owed the federal government 9 years of back taxes. Starting on November 21st, 2019, my mother, Sheena Mae Winnie, was wrongfully abused in the conservator guardian case 1CG 191000045 in the state of Hawaii. My mother was immediately declared incapacitated by the court without any evidentiary hearing regarding her capacity as required by Hawaii law and the Constitution of the United States. The court-appointed attorneys in the state of Hawaii openly engaged with Ralph Winnie Sr. and his attorney, filing frivolous pleadings and diligently working to suppress all evidence provided to the court to support my mother, Sheena Mae Winnie's credible allegations of Ralph Sr.'s marital infidelity, and 2, his serious ongoing financial problems. Instead, my mother was flatly denied by the court her right to have an attorney of her own. This despite repeatedly telling the court-appointed attorneys that she did not want Ralph Sr. in control of her care or her finances, and that she wanted a divorce. Far from acting in my mother's interests, the Hawaii court-appointed attorney simply ignored her, having already decided on pursuing the claim that my mother was incapacitated. My mother died on October 17, 2020, after being warehoused to die in a facility where she never consented to enter in the first place. My mother was tricked into leaving her home by being told by the smooth-talking special conservator that she would be, quote, visiting a spa, end quote, and would then return home. My mother, Sheena Mae Winnie, said goodbye to her favorite dog, Chloe, promising to return home soon to play with her. My mother will my mother willingly left her home with a special conservator, but instead of the spa outing she was promised, my mother was placed in a locked facility against her will. When my mother actively complained to the staff, telling them that she wanted to go home and would call the police to assist her, my mother was strapped to her bed, and the staff administered to her a powerful antipsychotic drug called Seroquel, a generic quetiapine. This drug is given to psychotics and schizophrenics, displaying violent, physically resistive behavior. My mother, Sheena Winnie, was neither psychotic nor schizophrenic, and the extent of her, quote, resistance, end quote, was to tell staff that if she wasn't allowed to return home, she'd call the cops. The staff's repeated administration of this powerful and medically inappropriate drug to my mother likely contributed substantially to her death within months of her confinement. Since I chose to oppose Ralph Winnie Sr.'s disgusting petition, Ralph Winnie Sr. and the Hawaii courts have sought to destroy me both personally and financially, which I vigorously fought against since 2019. I have incurred attorney's fees and costs totaling $769,840.40 and additional fees and costs totaling $5,245,424.79. I also submitted an inventory of my property located at my home, 816 Pahumili Place in Kailua, Hawaii, and have been denied access by a corrupt Hawaii judiciary that has allowed my personal property to be unlawfully commingled with the property belonging to Ralph Winnie Sr. In March 2023, I submitted testimony to the Senate Special Committee on Aging and met with Senators Bob Casey of Pennsylvania and Mike Rounds of Indiana to help me in my fight against estate trafficking. These legislators refused to take any action, and I continue to suffer emotional and monetary damages based on these legislators refusing to actively assist me in my fight against a corrupt judiciary in the state of Hawaii, which is actively involved in illegal estate trafficking, which ultimately led to my mother's demise. One of the most telling pieces of evidence that I submitted was a 1 cm laceration on the back of my mother's head. You can see from the picture that this was blunt force trauma. My mother did not just fall on her own. Someone had to have come behind her and administered that wound, which caused the 1 cm laceration. The other telling piece of documentation is the fact that my half-sister and father apparently found my Social Security card in my mother's wallet. My mother had asked me to give that to her because she wanted to make changes to the stocks and to add me. And so she needed my Social Security number to be able to legally do that, so that I would be entitled to her money, her stocks. And once my half sister and father found that, they suppressed it. And ultimately, they used it as a form of a backup creditor, because in order to get my mother into the facility in Hawaii, because she was elderly, they needed to, the nursing home needed someone to guarantee payment. And they weren't going to use my father because of his debts and his problems with the IRS, nor did they use my sister. So I was unwillingly drafted into the role of backup creditor in case my mother died before any money could be transferred to pay for her, stay at that facility. The other thing that was done that is also telling is my home in 816 Pahumili Place in Kailua, Hawaii. My father, Ralph Sr., was the corrupt attorneys demanded that my father enter into a reverse mortgage and for $2.2 million on a property that was worth at most $1.3 million at the time. in an effort to secure funding for the attorney's fees. What these parasitic attorneys do is they deliberately cause emotional harm, pitting parties against each other to drive up litigation costs. And then once all the money runs out, then they depart, leaving, all the family members in emotional and financial ruin. So I'm happy to take any questions. Thank you very much for allowing me to provide my testimony.
Appreciate that, sir. Go ahead, Michelle.
And we would also like to make a note here that these documents are being done, that your testimonies, and they are counterfeit through perjury and forgery. And so we want to make that very clear to the jury that are listening, that the documents that people are discussing are counterfeit, perjury, and forgery documents. Okay? Thank you, John.
With that, we're going to kick over to Linda Nash with the Homeowners Legal Rights Coalition out of Florida. Go ahead, Linda.
Hi, I wanted to talk on the sovereignty of owning American land. I founded Homeowners Legal Rights out of necessity after being unable to survive title theft myself. I discovered a systematic betrayal. All three branches of government, federal, state, and local, are failing in their oaths of office. They have abandoned their core mission to protect, serve, and provide opportunity for we the people. The power of the title. Both citizens and government officials are blind to the immense power of private land ownership. A perfected chain of title carries absolute constitutional protections. It can never be lawful to transfer through fraud, forgery, or deception title to American soil. To secure a mortgage, a buyer must hold a warranted interest in the land, yet homeowners are never taught. Government actively ignores the powerful guarantee behind these ownership levels. It's an ultimate guarantee. This guarantee is absolute. It pledges the full faith and support of both the United States government and your individual state to defend your property rights against all enemies, foreign and domestic. This is not a theory. It is law of the land, anchored in the Northwest Ordinance of 1787, the Bill of Rights, the United States Constitution, and United States Supreme Court rulings. No one is above the law. Whether you're a judge, an attorney, law enforcement officer, private corporate CEO, politician, or retail clerk, if your feet are planted on American soil, you are subject to the law of this land. Furthermore, there are no statutes of limitations on first-degree murder, treason, or deed fraud. No government agency, sponsored entity, or sanctioned corporation can grant itself power that bypasses constitutional restrictions. Under the Declaration of Independence, government power stops where our inherent rights begin. We are not helpless, and we are not silent. We've launched a national remonstrance, an absolute formal declaration of grievance backed by sovereign authority of the states and we the people. This is our lawful constitutional demand for the immediate cessation of deed fraud and the restoration of unbroken chain of title. This is our line in the sand. Any official who ignores this demand is complicit. These are not the actions of a legitimate system. These are the acts of a brutally abusive regime that has captured and is holding hostage our Constitution and Constitution government. Any judge hold court and ruling that homeowner can be deprived of their home and their land by entities who have filed fraudulent forged documents and broken the laws and the chain of title that protects homeowners is violating their oath of office, warring on the Constitution, this nation, and its people, and thereby committing treason. These are the things that I think everyone should know.
All right, thank you, Maine. With that, we're going to slide over to Tom Kibler, acting on behalf of American Property Owners Network. I think you were a founding member, correct, sir?
That's correct. Good morning, everyone. I'm Tom Kibler, as John said, a co-founder of the American Property Owners Network. We were formed to stand alongside other groups like Homeowners Legal Rights in order to leverage our membership to advocate for judicial reform and to demand compliance with the April 4th, 2012 National Mortgage Settlement Consent Judgment, where banks and servicers made empty promises to cease and desist creating forged documents and using them in land records and courts to steal our homes and our land. The consent judgment purportedly distributed $25 billion to 49 states. It was supposed to, number one, compensate homeowners injured by fraudulent filings and invalid foreclosures. Number two, purge the land records of the rampant epidemic of forged documents and put a stop to them. And number three, fund the investigation and prosecution of the criminals by the states, since the federal government had promised not to in the agreement. Unfortunately, looks like most of the funds were swept into the state's general funds. It's been 14 years, millions of homes, and we're still waiting. It's egregious maladministration. JP Morgan Chase promised in that consent judgment not to forge documents to steal homes anymore. But 6 months later, they created a forgery that has slandered my title since October 11th, 2012. An assignment in 2012, of course, to a trust that closed in 2005 and terminated with the SEC in 2006 is illegal and impossible. Chase had no interest to assign, and by affidavit, their robo-signer, who was just a seasonal temp clerk, posing as a vice president of Chase, admitted that he had no knowledge or authority. And the purported endorser of the counterfeit note that the lawyers presented in court declared that that endorsement too was a forgery. By declaration, he said he'd never endorsed a single note. Somebody applied a rubber stamp of his name to millions of properties, it seems like, after they replaced Cynthia Riley's forged rubber stamp with his. Published research has irrefutably proven that Chase lied about acquiring interest from the FDIC of millions of Long Beach and WAMU mortgages. FDIC has admitted that, Federal Reserve Board of Governors has admitted that, and Bill Padlow's research is definitive. But Chase, in league with firms like BB&TC, Deutsche Bank National Trust Company, and SPS, Select Portfolio Servicing, have stolen millions of homes. Attorney Kevin Dobie and attorney Orrin Kipp, with no proof of engagement, filed claiming to represent Deutsche Bank National Trust Company in judicial actions against me after more than a dozen non-judicial foreclosure attempts failed. They presented forged documents and counterfeit instruments. Judge Richard Kyle, Judge Laura Nelson, and Judge Katie Bergstrom moved without jurisdiction, issuing void judgments. They denied due process of law. Excuse me. Despite many material fact issues, they did issue, again, summary judgments, which is against their rules. And they also ignored challenges to standing, challenges to agency, and the fact that even a legitimate action was told out by the statute of limitations. With 3 witnesses, I attended the staged sale of my home, and there was no required bidding. Attorney Kevin Doby handed a company check rather than the required cashier's check or certified funds to a man costumed as and calling himself Marshall. Ramsey County subsequently has admitted via Data Practices Act requests that they don't know who this Marshall is. He was not an employee, even though this sale was held at the sheriff's office. They know nothing about the check, and they say they have no required accounting records. On January 17th, 2023, I was hit at my house by several armed deputies, forcibly removed me, and they, of course, had no writ or no warrant as well. I've been injured here by the slander of my title and my credit, the 3 void judgments, the fake sale, the theft of my home, and my personal property, not to mention the stress-induced open heart surgeries that left me permanently disabled and ended my career prematurely in 2017. I've been let down by Kim Waltz, Keith Ellison, the Minnesota BCA, dozens of other state employees in Minnesota, and dozens of Ramsey County and City of New Brighton employees, all of whom have shirked their sworn fiduciary duties to protect people's rights and property. If I were to quantify my injuries and losses, it's very simple. $400,000 home, $300,000 in personal property, hundreds of thousands of dollars in lost income, and a conveyance ignoring my protective lien, which is still unsatisfied and in first position. That lien is $2.8 million. I would throw in, of course, treble damages for fraud. Biblically, they say 7-fold for a thief. The evidence that I've included in my presentation, and which is available at my website as well, is the facially invalid forged assignment, the robo affidavit, the counterfeit note with forged endorsement, and the declaration of Jess Almanza, who was the man whose endorsement was forged. I'd just like to add that in all cases, there must be a real party in interest, pleading standing, which requires a concrete injury in fact in order to invoke jurisdiction of the court. That's not existent here. These false claims by fictitious plaintiffs should have been dismissed. The 3 serial felon firms involved, none of which I had an account with or had any debt to, appear near the top of the Violation Trackers 100 website. JP Morgan Chase is number 2 at over $40.2 billion. UBS, the former parent of SPS, is number 4 at over $32.1 billion. And Deutsche Bank, purported parent of DBNTC, is number 10 at over $20 billion. Combined, these firms have incurred $92.3 billion in penalties. How many stolen homes paid those fines? It's black letter law, as Linda had referenced. No title to property may ever be conveyed by fraud, and there is no statute of limitations for these crimes. And a maximum of law says property in possession of pirates does not change ownership. Congress, DOJ, and the Fraud Task Force, we, the people, require redress and remedy. Please take action. Lastly, I'll just say all of my evidence and all of the facts are at my personal website, which is one word. It's www.1694 Valerie, Valerie Lane, New Brighton, BRIGHTON.MN.com. Thank you.
Thank
Sorry
you.
about that. Middle of multitasking. Thank you for that, Tom.
bet.
With that, we're going to step forward to Helen Edwards out of Australia and a U.S. whistleblower. Are you stateside, ma'am, or are you out down in Australia? You'll have to unmute, Helen.
We, the people, require redress and remedy.
Mute your background.
Yeah, am I right to go?
Yep, you're good to go, ma'am.
Website.
Oh, hang on. Come back on. Okay. My name is Helen Edwards of Redcliffe, Victoria in Australia. My testimony, and I'm hereby declaring today the following is true. I'm going to have to shut that other thing off. I do apologise. I hereby declare the following is true and correct based on my own evidence and experience. My case of many fraudulent encounters began in 2010 when I was sharing my cause on Facebook to help raise awareness about people with disabilities and special needs. I was approached on Facebook by the first fraudulent identity, in which I am now aware of their actual identity. A cyber tracking report is available upon request. The next part of the fraudulent activity was on the first occasion, this fraudulent identity from the US, apparently, above sent me a valid physical check from an organization in the United States. These low-life criminals know the process for check clearance in Australia is 28 days. I never believed the check would clear and was surprised when the Commonwealth Bank of Australia took receipt of this check with no questions asked. I waited nervously for the Commonwealth Bank of Australia, AUSTRAC, our regulator, Australian Taxation Office, and our federal police to question me, as it was a total red flag and way above the $10,000 based on the guidelines of AUSTRAC. Now, totally out of character with any normal activity in my account. Leading up to the 28 days, these low-level criminals come up with stories of where some of this money is to be sent in other countries. So money laundering. This is now the beginning of where they start to blackmail you. There were several other people involved leading up to this time. Soon after this check cleared, I went to the Commonwealth Bank and arranged per the low-level criminals' instruction to transfer a larger sum of money to an account in the United Kingdom. Again, the Commonwealth Bank arranged an international transfer without any questions. There were then several fraudulent counterfeit checks after this. The Commonwealth Bank took all of these fraudulent checks and over time and either advised they were counterfeit and in one instance returned an international check via normal mail as it was not signed. A full list of these checks is attached to my testimony. All this time I was waiting for law enforcement, etc., to question me, but none to date. I had to approach them. It's been a joke since then. After a year or two, I was in such a bad way and living a double life and totally scared of these low-life criminals and their ongoing blackmail and death threats. I started to consider ending my life as I was so trapped. I told the low-level criminals from early on that I was going to the police. They laughed and said, "Go on, no one in your country cares. We have been doing this for years." They were correct, as now, based on my own international audit trail of evidence, confirms this from the late Queen Elizabeth down, as no one would act. I did eventually go to the Australian Federal Police in 2014, who said to me, "Yes, this happens 10 plus times a day. Just change your phone number and email address and move on." But as there were death threats, which is supposedly a criminal offence, to contact the ACORN, which is our Australian Cybercrime Department. From then on, I have now documented evidence of hundreds, if not thousands, I have engaged with in Australia and internationally, who have either acknowledged and ignored or outright ignored from the late Queen Elizabeth down. I actually did receive an acknowledgement from the SEC whistleblower submission at their request to submit in 2015. I have the reference number from the Securities Exchange Commission, and the reference was HO and then 0051719HO. The SEC advised me that they would speak to their legal department and get back to me, but I've had no further contact from them. This is international money laundering and counterfeiting. I also received a response from the FBI IC3 website, which is International Cybercrime, in 2014. I have their complaint number on the 10th of December, and that was I 141-209-22-13276-221. So I was all reporting international crime to the United States as the criminal transaction started from the United States. I continued to pursue help, and back in March 2017, I also received an email response from the Australian FBI attaché in Canberra, and they actually wrote to me and said, wishing me good luck in my fight. And I have the correspondence available upon request, and I've had no further response from the FBI IC to date as well. I had engaged with so many and still no law enforcement or government support me to date. I have since learned that they were all part of a fraudulent foreign corporation deceiving Australia and the world. Hence, no one had any authority to act, which we've heard in previous cases. Those I sought help from were themselves big-time criminals, a cartel. I can now look back and I can now laugh that I was documenting the incompetence and the failure of this worldwide cartel due to their own non-action. I have also since learned many of these are being dealt with under military tribunals for crimes against humanity and crimes beyond comprehension. I actually joined Renee Power and her remonstrance team a few years back as a whistleblower, and I am now officially a whistleblower team member of toll&roll. I can provide all my submissions to various organisations upon request. This includes the International Criminal Court in The Hague back in 2019, who acknowledged, and then they requested further evidence and then advised they can no longer assist. I have attached 4 documents to this statement for submission and consideration. I have a full list of fraud-related counterfeit checks and international transactions exposing 6 countries' failure to act. Overview summary of the various organisations I engage with on an international level who have either acknowledged and ignored or just outright ignored. I have a document where we can follow the money from the original check, which originated in the USA, and it travels across 6 countries, which originated, yes, from the USA. Now, this is derived from a report that we can get from the Australian AUSTRAC regulation department. So I have an audit trail that's fully, transparent. I also have a high-level impact and all the organisations involved in aiding and abetting international fraud and transactions. Just as far as the impacts go, and some of these were relevant to myself, but I know there's another case with Western Union where there were 500,000 customers who have received back $586 million. I've got evidence of some people have actually either killed themselves, killed their wife, killed themselves due to loss of money through fraud and extortion and so on. Suicide, people have been kidnapped. I was blackmailed, extorted, and like I said, nearly died. I've been emotionally destroyed over time, financially destroyed because money was extorted. Some people have become bankrupt. They've had loss of income, loss of their superannuation, and loss of their homes. And overall, basically post-traumatic stress. Again, I have a lot of evidence over probably the last 10 years, which is all available for this submission. So thank you.
Thank you, ma'am. Appreciate that. And as she stated, we all can relate to a lot of the things she spoke about. People committing suicide over this mess, all the things. With that, we're going to step forward to Julie McCloskey. She's another whistleblower. Go ahead and take it, ma'am.
Good morning. My name is Julie McCloskey. I own rural property in San Luis Obispo County that overlies the Paso Robles groundwater basin. I respectfully submit this statement in support of toll&roll's affidavit of remedy to the petition of remonstrance and a demand for enforcement. I specifically provide this statement to support Section 5 foreign citizenship, and property ownership that threatens the United States' national security and state sovereignty. In March of 2016, I became aware that Harvard was purchasing vast amounts of land in the Paso Robles area. I personally drafted a letter sent on behalf of another rural landowner to Harvard Management Company, raising concerns about land purchases it made through one of its corporate entities. I observed and noted within the letter that Harvard had a local agent actively involved in efforts to form a water district above the Paso Robles groundwater basin. Ultimately, in 2017, the water district was formed. It is important to note to the jury that my property does not fall within the district. I am purely providing this information as a witness to the information so the jury is aware. Today, Harvard's agent serves as a director on the district's board and as chair of the Paso Robles Groundwater Authority, called PRAGA. PRAGA has legal authority to manage and regulate groundwater in the Paso Robles groundwater basin. In June of 2020, approximately 7,104 acres were transferred to Kylix Vineyards California LP and related Delaware entities. Of those acres, 5,167 came from the mentioned Harvard-linked corporation. These entities are now connected to the Canadian Federal Pension Fund, PSP Investments, based on what I know. On August 4th, 2023, one of the entities, Truesdale LP, designated Harvard's agent as its representative. The water district on whose board Harvard's agent sits is now seeking rights to divert up to 28,000 acre-feet per year from public reservoirs for recharge infrastructure. To put that into perspective for the jury, 28,000 acre-feet is enough water to supply roughly 50,000 to 80,000 average California households for an entire year. When local residents submitted Public Record Act requests for ownership and governance information, the district's legal counsel limited or denied those requests. These records clearly show that it remains difficult to determine who ultimately controls these properties and what their interests are in the Paso Robles groundwater basin. These facts also show a clear pattern. The same local agent who represented the original Harvard-linked entity and helped form the water district now represents entities tied to a major Canadian pension fund while serving on the board of the district seeking to control a very large volume of public water resources. This is the type of foreign-linked ownership and lack of transparency that Section 5 of the Affidavit of Remedy identifies as raising serious concerns for national security and state sovereignty. That is why the remedies in the Affidavit of Remedy are needed. We deserve full transparency regarding who controls our land and our water. Thank you.
Thank you for that, Julie. Next, we're going to have another whistleblower. Go ahead and take it, Renee Weiler. If you're not on, take yourself off mute if you can. Can you hear me, Renee? Okay, she might be experiencing technical difficulties. So do we have, I don't think we have Tiffany in here yet. See if I can get her nope, I can't get her unmuted. All right.
John, I just texted you. Call Luann. Her and Robin are on next.
Okay, go ahead and call Luann up on podium.
She's here.
All right.
It was Robin.
Okay, gotcha. All right, copy that. Go ahead, Luann. We'll take you to the floor.
Okay, I'm trying to get my document here. Hi, let me close this off first. My name is Loanne Fleming. I'm a co-founder of Families Against Court Embezzlement Unethical Standards Face Us, a nonprofit organization. The probatetrap.org is our website. Thank you. To help address the systemic flaws in our court system, we've discovered it's nearly impossible to find counsel to emancipate from a fraudulent adult guardianship. However, the most avaricious guardians have a plethora of attorneys willing to defend them as the victimization grows unchecked. Courts not only allow but facilitate and reward unethical standards leading to court embezzlement. Our goal is to restore transparency and accountability in our courts to ensure every person has due process, the right to have their own attorney, and honor estate planning documents. There are 1.5 million to over 3 million active adult guardianships and over 300 billion in assets controlled and growing. The most vulnerable people who've committed no crime or stripped of their dignity, voice, freedom, life savings, homes, and personal belongings. Many are locked in facilities or grouped homes, isolated, medicated, and often they die alone. This system is poorly regulated, and there's no recourse for those abused through the guardianship system. We are a host of 2 radio shows, Hidden Truth Revealed and The Probate Trap. We've heard thousands and thousands of stories for over the past 10 years. Shocking, disturbing indeed. Guardianship should be used as a last resort because it removes the individual rights and restricts the person's independence. 14 years earlier, everything changed when my dad passed away. My family became legal hostages. Grief and animosity, I can hardly say that word, forced us into probate. In 2010, we felt positive going to court to get guardianship of our mother would quickly free her. Mom losing her memory, family arguing, the court seemed more about controlling family assets than her best interest. February 2020, my mom passed away. Mom and Ed, we call them, had ironclad documents designed to see that Marion was well provided for and leave their legacy. In March 2009, Ed and Marion's older children hired an attorney to remove family trustees. The judge ordered mediation and appointed a public administrator who stayed on for 10 years, controlling us until Mom died. Before court, the family had 5 properties. One was sold, the other remodeled for rental. We had 123 antique cars on the property and 9 motorcycles. Marion had Social Security and a pension. Her estate was growing. We were a happy family. Her children had stable places to live. When the court took over, liquidation began. Court documents say the 4 trust properties were sold in 2010 for approximately $225,500. We were offered to buy back our own property that our family owned for over 50 years. We couldn't afford it. We lost it all. The antique car collection was liquidated for more than a little scrap metal, so the court could sell the property, benefiting them, not us. Marion received $26,000 in the last 10 years, including her funeral. Family heirs received $75,404 divided 6 ways. The 39 grandchildren received 0. Marion and her family had paid $95,600 in legal expenses. The rest of the trust money, $124,000, went to pay the public administrator and the court-appointed attorneys. There were numerous errors and property missing. Over $90,000 wasn't reported to the court. Research on Zillow estimates that in February 11, 2026 showed the market value of our property taken was over $3,396,000. We sought out Senator Laura Woods and filled out theft fraud reports for over 100 families. Many more couldn't come forward in fear of retaliation by court-appointed attorneys. They had their parents or their loved ones. We enlisted the help of Representative Javon Melton, Representative Kim Ransom, Senator Morgan Carroll, Representative Jonathan Singer, Attorney General, the Governor of the Office of Attorney Regulations, and many more agencies. That would not help. After losing everything, property, homes, valuables, fighting for guardianship for mom, we had to deal with high attorney fees, evictions, impoverishment, sadness, depression, betrayal, anger, and destroyed family bonds, which are unlikely to ever be restored. We've been working with Rick Black from SEER, Stephen Phillips, and 2 law professors from Northwestern University Pritzker School of Law and professors of finance at Northwestern Kellogg School of Management. Bernard Black and his wife Kate Litvack are both victims of the Denver probate court while protecting his sister in guardianship for over 10 years, costing them millions of dollars in fees and false accusations. His full story is on the Probate Trap website, Rumble, Facebook, and X. Anyone can be a victim of guardianship, even a law professor. We're seriously all in trouble, everyone. This public awareness and health hazard is becoming a global humanitarian crisis. Our upcoming book is called The Probate Trap: How Families Lose Fortunes, Freedom, and Loved Ones. Everyone must educate yourself, take precautions so neither you nor your loved ones falls into the probate trap and become legal hostages of the court. Thank you.
Thank you for that, Luann.
You're
And I
welcome.
believe directly behind you, we had a little bit from Robin as well. Good morning, sir.
Austin. I'm one of the co-founders of Families Against Court Embezzlement Unethical Standards. Our radio show over the last 10 years has heard thousands of stories corroborating the testimony of all the witnesses that you've heard today with their own stories of similar events in their own lives. We have a thorough understanding of how corrupt the courts are in this country and throughout the world. We've had call-ins from all over the world. And I just want to say that this is a problem that, if it is not addressed, is the downfall of our government and the organization of our country under the Constitution. The violation of constitutional rights is unprecedented and unimaginable, and we must address these problems. Thank you.
I thank you, sir. And I believe right now our next speaker had to go to work, unfortunately. And if we've got it ready, we're going to play a clip video from her mom.
Do we want to play the whole clip, the whole 5 minutes, or just a portion of her mom?
Go ahead. Nope, we've allotted time for it. So go ahead, Steve.
All right.
Take it away, bud.
Thank you all for being here today and for allowing me to speak alongside this incredible group of whistleblowers. My name is Allie Carino, and like many of you, I never imagined I'd be here as a victim and an advocate. I'm not here to give legal advice, but I am here to issue a public warning. Don't fall into what so many of us now call the probate trap. I was born and raised in Trumbull County, Ohio. I come from a big family in a small farm in Bristolville. My dad was an Army veteran, a pharmacist, and a football coach. My mom, a self-made, strong woman and churchgoer, a real estate agent, and a dedicated cashier at CVS, and raised our family. She lived simply and with dignity. That dignity was stolen from her by the very system that was supposed to protect her. In 2018, without her consent or even her full understanding, my mother was forced into guardianship, stripped of her rights, removed from her home, and placed in a locked memory care unit with an ankle monitor on her leg. She was never diagnosed with dementia. She had a UTI and seasonal depression, and yet her doctor, who happened to be the medical director at the same facility, declared her incompetent and refused to acknowledge her valid and properly recorded durable power of attorney. I want you to hear in my mom's voice and her words how she felt in 2019 before I knew we were targeted and this was actually the probate trap.
Mom, what's wrong? I don't want to be here. He dragged me in here and took all my clothes and put it instead. Mama. What are you doing here? I come to see you. What do you mean you came to see me? I came to visit you. I want to go home. I don't belong here. I know, it's beyond my control. Why? There's nothing I can do. I'm trying to help you, but I'm cold. Oh, you want your jacket on? You want your jacket? I'm ready. Put a jacket on me. My limbs are cold. Feel how shivery I am. You feel warm, but your hands are kind of cold. I was hoping you'd still be up, because then I could take you outside. I don't want to go home. I want to go home. I don't want to be here. I don't want to be here. I don't know who to put me here. Can you sit up? You don't look comfortable at all. I'm not comfortable. Here, why don't you sit up? And I'll just get your pillow behind you. Is that better? No. It's better, but it's cold. Here, we can put this jacket on you. Oh, it's so cold. I don't mean to sound like a baby, but I can't help it. I know. Why am I here? What did I deserve being in a place like this? I don't know. I don't either. Oh, pull it down in the bed. Oh. I know. It's beyond my control.
My mom was denied her basic rights. No independent valuation, no choice of legal counsel, no fair hearing. This was not a mistake. It was a planned and profit-driven seizure of her life, her voice, and her property. The very people profiting from her guardianship used family discord as their excuse to take everything from her, including her freedom and mine to care for her. I watched her health decline rapidly under court-appointed control. She was neglected, isolated, and used as a revenue stream. Despite repeated pleas for a compassionate release, including letters from national advocates, she was imprisoned until her death on January 15th, 2024. This isn't just my story. It's happening across Ohio and across the nation. Guardianship has become human and estate trafficking, legalized, systemized, and weaponized. I am so disappointed and disgusted that this happened to my mom. I will continue to fight in my mother's honor and for every family suffering in silence. We must end this abuse, and we must do it now.
Thank you for that, Stephen. You know, if anybody didn't pull a tear on that, you got a problem.
Yeah, that definitely brought me a tear.
You know, that's a pretty heavy statement for the probate, you know, for senior citizens, for all of us. And unfortunately, it's still happening all over the country. And that's why we're all here to stop, hopefully, that process. And sorry, I'm getting multitasking going on. So with that, we're gonna power forward. We're gonna take Renee Weiler. She was having technical difficulties. So Renee, if you can bounce in, I think you're a phone call in. So if you can get in, go ahead and take it. And then after her, we're gonna go. I think Tiffany will be next. So stand by, Tiffany. Can we make it happen, Renee Weiler? All right, Billy, I'm not sure what's going on. We're going to go ahead with Tiffany. Go ahead, take it, Tiffany. Somebody will have to unmute Tiffany. Oh, I think there we go. It's very quiet.
Can you hear me?
You're there, but you're real quiet.
Okay, if I have to do a earpiece, let me know, because I don't know how to turn the volume up. Let me see if I can get rid of this, if this helps.
No, I think you're good now. I think we can hear you.
Okay. I'm good to go?
Yes, ma'am.
All right. My name is Tiffany Anderson, and I was an employee of San Joaquin County Mosquito and Vector Control District from the years April 19th, 2004 through December 30th of 2011. In my first year, I was assigned to spray and test the waters of the White Slough Fish Hatchery, where I broke out in rashes with flu, lung issues, and chronic fatigue, treated by my employer's physician, where I would be in a workers' comp arena from the beginning of my employment until 2020. So they neglected to, I was not licensed, nor was I certified to be a pesticide applicator at that time. I would not be certified for 1 year, which means every exposure I had, my employer had an obligation and a commitment to do everything that was required by law, and which was required by their NPEDS application, their National Pollutant Discharge and Elimination Systems application that they would have to apply for every year, giving them state permission to use chemicals. So what they neglected to tell me or my physicians was that they were spraying formalin, which is formaldehyde, a Prop 65 known carcinogen in California, along with copper sulfate and other chemicals in these ponds without employees' knowledge or consent. I was hired to spray, handle, and transfer chemicals throughout the county and to educate the public on West Nile virus that was providing us heavy federal, state, and emergency funding. In 2006, I was required to give oral testimony to my employer's self-insured workers' comp investigators and the risk management over a heart attack of my fellow and co-worker that stemmed from retaliation for reporting sexual harassment and misconduct in the workplace with management's approval while hiding a conspiracy to spray these chemicals on site. That is the testimony that I gave at that time. Of course, I didn't know about the illegal use of the chemicals. It was my employer's fault, and it was due to harassment and retaliation, the heart attack, for reporting wrongdoing by the employee in the workplace, which caused him a heart attack at work and would go through the workers' comp arena for 2 years. In 2007, I would file my own sexual harassment and retaliation claims along with hostile work environment against the same supervisor 1 year later with the same results. The employer's protection of the behavior with more retaliation and hostility. I was relocated as a result to the most labor-intensive territory where the previous employee was removed with medical conditions and forced into retirement. I would endure my first year in that zone. I think I left something. I think I endured my first. The retaliation and harassment in the first. I'm not sure where I was going with that, but all the tools
were removed from my access, hoping mosquitoes would get out of control and they could terminate my employment by having public complaints. In the summer of 2008, management gave the problem supervisor, the one that I had filed my sexual harassment complaint against, authority to retaliate against me with an evaluation. And on that same day, his buddy, my new supervisor, did as well. Those were my first two negative evaluations up until 2008. All of my evaluations have been, had been good. There had been no problems with me until I filed that complaint. In 2009, I would be removed for my first right knee surgery. And at this time, I filed a complaint with the Department of Fair Housing and Employment. And I also filed a grand jury complaint. During this time, my previous supervisor, Dwayne Bridgewater, would die 6 months after he retired of 39 years of service. The last 2 years, he was assigned at the White Slough Fish Hatchery where they were spraying the formalin and copper sulfate. In 2010, I returned from my first knee surgery and I would file an anonymous whistleblower complaint against my manager who handed them out and said, if you don't like the way I handle things, call this number, which was a whistleblower hotline. And he got the call either through his risk management, but he was the one who organized and did his own investigation with the support of the Board of Trustees. In 2010, the grand jury began their investigation with Chet Samara, who at that time was a Lodi police officer, and Trudy Reed, and she was a previous whistleblower herself. They were my first point of contact while I was still working. All the employees and board members were interviewed, and it was the most hostile experience and I endured my second knee surgery. Trudy Reed told me she wrote the findings herself and they were in my favor, but the foreman, who was tied to my agency, voted it down, pressuring the group. So there would pursue a second investigation where they would throw out all my testimony, all of my evidence, and they would begin a new grand jury investigation. In 2011, a second grand jury panel was in session, starting all over, throwing out all previous evidence. By September, I had my third and final knee surgery where the employer involved himself with my medical care and made personal contact with the physician who ignored the metal T-post that ripped down my leg. And the point of contact started at my twice post-op incision. The physician returned me to work with a major trauma, bruised leg that was then subjected to dairy water with chemicals I used to treat the mosquito breeding at the dairy property that was over 100 acres of ponds and irrigated pastures. Ultimately, I found other doctors to document the injuries and I was removed in December. So the injuries happened in September. So I was exposed and I was forced to walk on this trauma injury until I could get a doctor to remove me from the workplace. I had a severe exposure and a compromised knee. While I was out on medical leave in December, sometime in that period of time, I was contacted by Mike Morris, a San Joaquin County DA investigator, and he would request my medical records while informing me that my employer had been illegally spraying and storing formaldehyde in a gas form at the White Slough facility and that this was a crime he was investigating. In the few weeks that it took me to get my medical records and documents together that he had requested, he had died. I returned to San Joaquin County DA's office to hand over the records Mike had requested, their deceased employee, and no one knew about his request or wanted my records, although I had forced them to take them. These medical records were incomplete and falsified as they came from my employer's medical providers. By this time, I had had 4 documented worker comp exposures, and I had had 4 documented worker comp knee claims filed. To date, I have been unsuccessful in getting a full complete set, although I have requested them through OSHA and EPA. By law, my employer is required to maintain a full set of exposure medical records for 30 years past my date of employment. They are also required every time that there is an exposure, that if an employee has symptoms past 3 days of exposures and they know it, they're required to report that to OSHA, and they have neglected to do so. In 2012, the grand jury released their findings, but they were very light on the manager, although he was forced to retire as a result of my complaint and their findings. The grand jury ignored all of the injuries I endured in their findings and never mentioned the crime at the White Slough facility and the 3 questionable deaths that have endured to date. The day of the 2012 findings, the Mosquito Vector Control Association of California gave my manager, John Stroh, the Manager of the Year award for mosquito control. And that was on the front page of the Stockton Record, while the grand jury findings were on the back page to minimize the findings even more. At this time, I filed a complaint with the EEOC, which would force my employer into awarding me a medical disability retirement while they forced me out of my job. That retirement was given to me in 2013, and it was retro back to 2012. In 2013, the Mosquito and Vector Control Association of California would create a mosquito foundation, and San Joaquin County Mosquito and Vector Control District retired manager John Stroh. He was actually the treasurer. I put in my document that he was the president, but I was wrong. They awarded him the treasurer of this new foundation. And the San Joaquin County Mosquito and Vector Control District gave the first donation they gave to this association was my annual salary. I have contacted and filed complaints with all agencies in California that governed my own, only to find that conflicts of interest always prevailed over justice. EPA and OSHA were given West Nile virus funds in awards that commingled in with my employer's award. Kamala Harris's office was referred to the formaldehyde use as a crime, and I also reported the workers' comp. What do I want to say? Workers' comp. I don't. If you're getting exposed to chemicals and you're a chemical agency spraying chemicals as a government agency, and you are saying that you're protecting the public's health, then you are required by law to comply with what those labels say. And if an employee is being exposed to chemicals and there's a reaction, those chemical reactions are supposed to be reported to the chemical companies so that the chemical companies can look at their chemicals and maybe have to change them or remove them from the list or change the wording on those. But that never took place. Instead, these exposure claims were handled in a workers' comp arena. From 2004 would be my first filing, and 2020 is when they settled my exposure claims. So I can just tell you that during that period of time, I saw many qualified medical examiners, and those medical examiners do not treat you. The only reason why they see you is to give your injuries a rate of pay. How much were you damaged? And instead of recording the true facts of the cases, they being paid by the employer and being paid by the employer's self-insured company and their risk managements, they would just continue to have you come back and see them over and over. I saw this Dr. Tabador multiple times, so you can find on my YouTube page 2 recorded testimonies, because I got so tired of being sent to him and his corruption, that I finally required in the workers' comp arena that my visits were being recorded, where I would actually give testimony and have my claims, because he was never writing what I was telling him, that these injuries came out of retaliation and different findings. There was also a doctor that they used for my exposure claims, and this doctor that they had assigned over me was the same doctor that they would retain in their trainings, to their trade shows, to fight the exact claim that I was filing. So they send me to a doctor that they're paying to do seminars to prevent the claims like mine. So the corruption in the workers' comp arena is very, I'm speechless. I'm just speechless. Let me finish my statement here. And it says, so let me see, Kamala Harris's office, formaldehyde used as a crime, portion only to end at her office. My complaint ended at her office as the federal government at that time was in their own litigations over Hurricane Katrina homes emitting formaldehyde gases. I have evidence of complaints filed and lame responses given, ignoring that this agency's mission statement was to protect the public health, only to do the opposite because an employee is at the front lines of all things. And if they're ignoring the employees' exposures, that means they're going out there, they're spraying these chemicals out in the public arena, and they're not reporting the true effects of what these chemicals do. These chemicals kill. They're made to kill. So I am asking for an investigation into this matter, as documents were falsified or destroyed, and the true nature of this matter was kept from my coworkers and the public. I will provide one piece of evidence, and I will provide more upon request. And my piece of evidence was interview of Tiffany Anderson on December 20th, 2013, recorded testimony on the White Slough, Lodi, California facility with the EPA OSHA violations. My recorded testimony was with the California EPA Department of Toxic Substances Control, and it's a YouTube link. And I think that that's all I have to say.
Thank you for that, Tiffany. With that said, Tiffany's testimony comes in from a different background. It's not a house, it's not a senior citizen, but it's still a personal problem. And the personal problem for the people is the government is not taking care of their constituents. That stated, her testimony is just as powerful and needed for the whole spectrum of why we're here doing this. With that, we'll step it off over there to you, Mr. Hilligus. How's it been, sir?
Good. Thank you, John. Can you hear me?
Yep.
All right, everybody. My name is Roger Hilligus. Just a quick background. I'm a member of many organizations across the country. I consider myself a nationwide advocate that work with the disabled and the elderly. My case is involving the state of Nevada. I am a 30-year retired disabled public servant over 40 years ago. And this testimony I'm about to give is going to be sworn to be the truth, the whole truth, based on the whole truth, so help me God. My mother, Susan L. Hilligus, and my father, Herbert E. Hilligus, created a trust and durable powers of attorney in 1993, naming me, their son, as their durable medical and financial powers of attorney and successor trustee of their assets and property. In 2014, both my parents had been diagnosed and tested by medical doctors with cognitive decline to the extent they required assistance with their ADLs. About this time, 3 falsified and perjured petitions were filed in family court, probate court, and district court. 2 of the falsified were guardianship petitions, using perjured and false statements to have a judge with a conflict of interest take improper jurisdiction over both my parents and their assets and their estate needlessly. I had engaged many local, state, and federal resources, and I was qualified and trained to provide the care and supervision that was required. Again, a jealous sibling, with the help of her divorce attorney, made false reports to law enforcement, hospital staff, APS, and the attorneys and court clerk to ensure the plundering of my parents' estate continued for 6 years. And guardians kept this racket running. Again, I engaged state and federal agencies through complaints, all to no avail, in an attempt to protect now only my mother, as my father had died at the hands of a guardian through neglect on hospice. Once I exhausted all remedies through state and federal complaints, I found a constitutional expert and filed to have the the case is heard by a jury. With the jury verdict in hand, myself and a 30-year law enforcement acquaintance and professional asked my mother a simple question, which was where she wanted to live and with whom. Because at this time she was in an assisted living facility where the patients, they call them patients, but they're not patients, they're residents, and they're elderly and they still have rights. My mother said, I want to live with you, my son, in her home, which was paid for, and there was no reason why she couldn't live in her home. So the locked facility opened the doors and waved and said, that's Roger, the son of Susan Hilligus, leaving together. Because the Reno Police Department told me it was a civil matter and they refused to assist me with a civil standby at the facility. What happened next is I was illegally tracked through a phone ping without a warrant. Next, the FBI was lied to, claiming I was armed and dangerous. So I was swatted by a SWAT team and snipers and tased in LA County sheriffs, who were also lied to, claiming I was dangerous and my mother needed drugs. When in fact, this was on the body camera of the Reno Police Department that responded to the facility, in which he told them that my mother, Susan, did not require life-saving medication. Finally, I was illegally extradited back to Reno, where under duress, I was forced to take a nolo contendere plea for a 24 to 36 months of probation. And lastly, the state of Nevada Parole and Probation Department filed for an honorable discharge of probation, but the corrupt judge denied my honorable discharge, even though the law says I have completed all probation conditions and paid all fees. This is the testimony of Roger Hilligus, who is a victim of corrupt legal system and court process. What I will finish with is this is showing a pattern in practice with everybody that's testifying. This is important that this is happening. Everything that I'm speaking of is on public record. There's been appeals. There's been a writ of cert to the United States Supreme Court. There's been a federal complaint and lawsuit. There's been, and this is the most important thing, there is a summary and a default judgment on the record of the Republic of Texas that's out there, that all of the respondents, which there's many, have all been given an opportunity, 3 opportunities to respond, and they failed. And so there is a default and summary judgment on all of the individuals involved in this case. It's a lot of corruption. Thank you for giving me the opportunity to speak. Thank you.
Not a problem, sir. All right. Renee Weiler, we're going to try you one more time, ma'am. Make it happen. All right. Whoever's in charge of Scott Staffney, or if Scott Staffney can come online, go ahead and come online, Scott Staffney. Your turn. I'm not sure if Steve or Billy needs to unmute their phone line. There we go. Take it away, Scott.
Okay, good morning. My name is Scott Eric Staffney. I'm a 77-year-old American citizen, a Christian, and for 50 years I operated as a third-generation lawyer inside the machine of American law. The Constitution begins with 3 simple words: we the people, not the government, Congress, or the courts. No branch of government can expand its own power by its own will without committing what Chief Justice John Marshall defined as institutional treason against the Constitution. Our constitutional balance has failed because Congress has abdicated its oversight functions. In that vacuum, automated systems have constructed sterile procedural boxes to insulate government power from the people the government is supposed to serve. For example, just this week in Trump v. Cook, the Supreme Court bypassed threshold jurisdictional rules to shield the Federal Reserve governor from being summarily fired by the president because of alleged financial fraud. Yet daily, inferior courts routinely deploy rigid procedural defaults to choke out the evidence vulnerable homeowners and family members seek to present in their cases, systemically denying these ordinary people their right to be heard. When the law grants complex protections to elites while enforcing automated procedures against ordinary citizens presenting their evidence, the system appears to be and does actually abandon justice based on fact-finding. Like Bastion in the never-ending story, you and I are no longer just passive observers of a historical text. Our presence here means we have chosen to become a part of that same history which has demanded throughout time that courts provide remedies for wrongs, including the wrongs imposed by courts on citizens. This grand jury should consider citizens' complaints against the courts of this nation openly, honestly, and with deep humility, because justice still matters to the people of this nation and the peoples of the world. Thank you.
Thank you, sir. All right, next up, Emily Hodgson. You there, ma'am?
Hey, I'm here. Sorry. Hey. All right. My name is Emily Hodgson, and I'm here today for trying to get protections for my family, the protections we desperately need. I might tear up, I'm sorry. And I lay bare the unimaginable nightmare that we have endured. For the last 6 years, our lives have been completely upended. We have been forced to move 12 times just to stay alive. We have had to stay in a safe house for one of those years. Our tragedy began in 2020, just 10 days before my mother was murdered. The ground was removed on base. They said it was done intentionally, documented under incident report number NCF 636BP. This happened 2 places we lived. I'm sorry. So after the morning after she died, there were 4 officers that came to do a welfare check. And when they came, this one officer was there twice in 2 hours. And finally, and they were not being kind, but I asked her, I said, where's my mom's body? She handed me her card and it said Hall Wynn Funeral Home, and it said what it said in the Durham, in the police system. All info to Baxter Walker, my brother-in-law. That's when things got really bad. Instead of being able to grieve my mom, we immediately were subjected to relentless gang stalking. We lost our home, our mountain land, other assets. We received death threats. We made reports, but everything was ignored. The hostility followed us into our vulnerable parts, like my son's exceptional children's program, our vehicles, the health system, and more. We sought help through many venues, many agencies, but instead of receiving any help, we just faced mistreatment from the police department and encountered severe fraud within the judicial system. Sorry. The ultimate cost of this failure was on April 26, 2026. Sorry. My daughter, while she was crossing, was killed by a vehicle. Sorry. She stated days before she died that she had never been so terrorized yet silenced in her life. To this right now, and that was April 26th, I'm still trying to fight for an autopsy. She's still not been cremated. To find out the truth of what happened to her. And that in itself is really, really hard. Sorry. No human being should have to survive the murder of both their mother, their child, and while being hunted and uprooted and denied basic justice. Every single day of these past 6 years has been a battle against fear, institutional betrayal, and profound grief. We have exhausted every option. We cannot move again. We cannot run anymore, and I won't. The protections and remedies I'm asking for today are not a luxury. They're an absolute baseline necessity to keep my surviving family alive. Surviving family alive. I ask you to look at the immense weight of what we have lost and to acknowledge the systematic failures that have brought us here, and to grant us legal protections and access to the correct justice we need to finally be safe. Sorry. I pray you hear my testimony and that action is given towards remedy and protections to our family. We failed my mother and we failed my baby girl. I ask that we no longer fail anyone else who is going through these injustices. Thank you.
Sorry for your loss. We haven't failed the system has failed us.
Yeah.
Our
family has been,
you know,
hindsight statistics are not what's supposed to run things.
right.
So,
that's dated. We're all stubborn to a fault. Power on.
All right. Thank you.
Keep on keeping on. All right. Moving forward, we've got Christine Grab, my apologies. Take it away, Christine.
Sorry, okay. My name is Christine Grab. I stand before you to testify regarding systematic institutional corruption within the California Franchise Tax Board, or FTB, which is protected by the other state agencies. Between 2008 and 2016, FTB cleared 20 timely payments made by me and my husband, but failed to apply 16 of them to our account. Because of their accounting failures, FTB aggressively harassed us and coerced us to pay tens of thousands of dollars above our actual tax liability. They also falsely imposed late fees, penalties, and interest. We submitted copies of our canceled checks 33 times. FTB ignored this paper trail. I have a rare kidney disease. The stress from the relentless harassment drove me to the brink of kidney failure. At the end of 2016, I begged my legislators to intervene. Only after their direct involvement did FTB locate our missing funds and stop the harassment. Every stage of FTB's administrative appeal process was corrupted to hide this fraud. I appealed to other state agencies. Instead of upholding the law, the state protected the perpetrators. I started with the Office of Tax Appeals. FTB carried the burden to prove that we were willfully negligent. FTB's attorney redacted and omitted records to obscure the accounting fraud, unlawful harassment, and the efforts we'd made. The judges failed to place FTB under oath, sided with the agency, and omitted the willful negligence requirement from their ruling. I filed a trial del novo in San Diego Superior Court. 3 FTB staff members submitted sworn evidence which contained 11 counts of perjury, 25 counts of obstruction of justice, 15 counts of collusion to cover up embezzlement, 8 counts of collusion to cover up racketeering, and an unlawful denial of records. The California Attorney General's office, acting as FTB's defense counsel, harassed me and retaliated by publishing my and my husband's social security numbers on the internet. The Superior Court judge dismissed my entire body of evidence on a technicality and issued a ruling that contradicted the statute cited. I filed complaints against both lawyers with the bar. The bar protected the attorneys. I filed an appeal with the California Supreme Court. They refused to review the case without explanation. Thanks to the records propounded in the Superior Court case, I now hold hard, undisputed proof of 8 distinct systematic criminal schemes to fraudulently overcharge taxpayers. I filed complaints with this proof with every regulatory body that I know of, including GovOps, the Auditor's Office, Orem, the state legislative tax committees, the Federal Department of Justice, the Federal Treasury, the FBI, and the White House. The response has been silence. I implore this grand jury to review the evidence and issue the indictments required to halt this systematic extortion. I have uploaded it all to my website, www.gwsandiego.net/blog. Thank you.
Thank you for that, Christine. Appreciate that. Mr. Class, are you ready to rock and roll?
Okay.
Yes. Ladies and gentlemen,
Systematic extortion.
I've listened to a lot of everything you've said here and said. Billy and John and Tom are trying to run Protect, which is what Michelle brought up earlier. Ladies, you don't understand how important this is. Every one of you that I've listened to, I'm going to tell you where your problem's at. I'm going to tell you why. 1996, the State Justice Institute and the Judicial Conference in Ohio met for over 2 hours. Thomas J. Moyer, Supreme Court judge, sat here and told the judges, the lawyers, and the prosecutors and other government officials, when the private citizen comes before you, rule against them. Do not allow them to win. If they're not going to hire one of our people, you rule against them. When it comes up to the appeal court, we'll back it. When it comes to the Supreme Court, we'll back you. We won't allow them. This is where so much of this has come in. This is where the classified of sovereign citizens come in. They talked about the grand juries, the common law side of this thing, and the common law courts. They went back and they made the issue on this video that they could never get a fair trial. They could never get a fair hearing from the people. So we can't allow them to have any foothold. If they're not willing to hire one of our attorneys, then we won't allow them to win in these courts. Thing of it is, with their grand jury, and I was before their grand jury,
Hey, I apologize, Rod. It's about testimony here, bud.
This is testimony.
Okay.
This is testimony. This is what I've run into for the last 26 years. This is why we're having the problems here. Going into every one of these courts, I've dealt with judges. I've dealt with attorneys. They've laughed at my paperwork. I've had them pull me off to the side and sit here and say, Rod, your paperwork, you're proving corruption in the court. You're not going to the right system. You're not going to the right place. I said, what do you mean? They would never tell me. Later on, I get another judge said, you didn't exhaust your administrative remedies. Well, what's my administrative remedies? They won't tell you. I've had FBI, U.S. Marshals, Sheriff Department walk into these courts, walk out, and look at me. He says, we can't believe that you proved corruption. I said, yes, that's what I do. I said, go arrest them. They looked at me and says, where do we take them? Where do we take them? That's where the problem's coming in. But from 2000 up to present date, I have been dealing with court systems. We've been dealing with their absolute corruption. I got charged in Ohio in 2000 for driving on an expired Ohio license that was turned into Florida with a valid Florida license, and they wouldn't allow it. I got busted in DC for carrying a carry concealed permit parked on property that had no posting on it under Title 18, 930, Section 8. They refused to uphold the Constitution. I've had a federal judge come up off the bench when I was pushing the laws and screamed at me and says, Mr. Class, we don't use laws in this courtroom. We use theories and concepts. And that's exactly what the attorney told me that they sit down and did as a public defender. Rod, we don't use laws. We use theories and concepts in these courts. I've had other attorneys tell me the same thing. What we're dealing with is an administrative agency. And in my document that you people have on the grand jury, you'll see that I went into administrative courts. In these administrative courts, I have went after them to have the administrative court come back and rule that these people don't work for the state, private contractors. They don't work here. We don't know who they are. But they are agencies of the state. Because they are agencies, not one of these agencies sit down and protect us. They're not designed to protect us. Supreme Court has made a number of rulings that sit back and says the police department and the state and the agencies have no obligation to protect the private individual. They have no obligation whatsoever. Now, private individual. Every one of you are in here talking about private individuals because they're using that. This is why we're having such an issue, because you're a private individual and they have no obligation to protect you. While in federal court, I went back and I proved that the United States codes were not passed. The United States code does not apply to us out here. And I'm going to have some controversy on that because I did in the federal court case. But when I put down the legislative document that made that issue, Judge Kessler and the prosecutor stopped and they shut the hearing down because I proved the United States laws don't apply to us. Supreme Court had made these rulings. Codes, regulations, and guidelines don't apply. It only applies to the administration and applies to government entities and to corporations, not to you and I. This is where it all lies at. It goes back into our lack of knowledge. We have put in these court documents, your state constitution, and in every state constitution, it sits here and says who holds the inherited political power. It relies back to the people. It goes back to the people. We hold the inherited political power. We are supposed to be in control. And they come back and say, well, you can't use the Constitution in a courtroom. Yes, I can. We got into these debates. You can't use the laws in these courtrooms. We got into these debates with them. This is what I have done for the last 26 years on arguing with these people and debating with these people. But your grand jury that I've been into, I pushed it under the Corpus Juris Secundum, Volume 38A. That grand jury, and the reason why you people are having problems with grand jury, the prosecutor is controlling it. When I talked to the grand jury and we got into the definition of the word firearm, and I brought in the National Firearms Act, the ATF law, and the IRS, the foreman said, whoa, Mr. Klaus, we're not in here to talk about definitions. We're only here for one thing. Were you or were you not in D.C. on this here date at this here time? That's the only thing that we're in here for. And if you're found guilty on that, then the prosecutor writes everything above that because you got a guilty verdict for being in someplace that you're allowed to be. Every one of these grand juries are rigged. The juries are rigged. Because I have sat in a number of these grand juries, including my own, to where who is sitting on the jury is lawyers' wives, police officers' son, government officials from the court, every entity that works on the government side. Anybody that is a non-government entity, the judge disqualifies them. I have been in 5 hearings personally where this was done and where this was exposed. And I went to the U.S. Marshals. I hold position as a private attorney general, and I hold position as a federal bounty hunter through legislation. I've had U.S. Marshals come to the house. I had FBI come to the house. I had the insurance commission stop me out on the street with cruisers around me. And I walked them through my congressional legislation. And they looked at me and says, my God, so you got more power than what we have. I said, yes, I do. Well, I walk into a federal court. I've had federal judges try to throw me out of a courtroom. I've had prosecutors try to throw me out of the courtroom. U.S. Marshals walked in and said, we can't touch him. He has every right to be in here as a witness. U.S. Marshals now leave the courthouse because they don't want to take a written complaint because, like they said, where do we take them? Who do we bring them up in front of? This is what Protect is about. Giving the people representation, because none of these agencies that I have come into has represented us. In 2008, we went before John Conyers and Patrick Leahy, a group of us. We took in the State Justice Institute video. We took in the Anti-Government Movement Handbook, which goes in and addresses how to rule against the American people, how to railroad the American people. We went before Congress on this. We addressed this stuff with them, and they said, well, we can't get involved. We can't get involved. Well, yes, you can, because federal funding is involved. Ladies and gentlemen, every one of your issues, and from what Michelle was talking about for a long time, agencies. All you guys are talking about, a lot of it is agencies. Agencies are not designed to protect the people. They're not here to protect us. They are here to manipulate the laws, because when Congress created legislation, they created a penalty. They did not create the issue to justify the penalty. If you stop and think, and I brought this up, Congress only does 2 things. They deal with foreign affairs and administration. They don't deal with John Q. Public. They don't deal with us. They deal with foreign affairs and government offices. They go back and reprimand. You and I are not on the list. This is why we're having a problem trying to get before Congress. This is why we're having an issue. This is why we need to be able to sit down and get a group, get a committee, get an agency that protects the people, that we have representation. We don't have it otherwise. And that's where we're running into so many problems. This is why I'm part of Toll and Roll with what we have done. This is what I have done over the years. There is no agency that protects us. And the attorneys have sit down and said, well, we're not here to protect you. We're here to cover up. We're here to make sure that a trial happens and any evidence that you bring in gets sidestepped to where you're not represented properly. This is where the issue comes in. The Bar Association, the attorneys, the court system, and the administrative side. The United States Constitution, under Article 1, Section 6, sits there and says that the legislation upon treason, bribery, or breach of peace can be removed and arrested. Under Article 2, Section 4, it sits there and says that the administrative side, under treason, bribery, high crimes, misdemeanors, can be removed. Under Article 3, it sits there and says good behavior. We can't do a whole lot about legislation on trying to remove them. But when it comes down to the administrative agency and it comes down to judicial, it sits there and says we have to go to legislation to remove them. This is where we have to be able to get in. We have to have an administrative agency to represent the people to get them into legislation for impeachment. This is why we're having such an issue. We're not going to the right places, and they are not telling us because they are aiding and abetting and covering up. I went back and I proved in a number of courts bankruptcy, 1933. You people were talking about the 1787. You're talking about prior Civil War stuff. It don't count, it don't work. Because in 1867, they did the Reconstruction Act, and this was part of my paperwork in D.C. that they sealed. I went back and I showed that every state official came under federal jurisdiction. They come under federal guidelines. That's why they had the 14th Amendment. When we started bringing up on the bankruptcy of a lot of this, of how and where, this is where the 1933 bankruptcy come in. And I brought this into the courts. There's so much that I brought into these courts. Under the 1933 bankruptcy, you and I was made enemies.
Hey, Rod, I hate to ask, but we got to wrap it up, sir.
All right.
If we can dial it in.
We was defined as enemies of the state. Social Security Act 1935. You got $1 million in your birth certificate account. I had a forensic auditor that was able to go back and prove this. I had a forensic auditor that was going back and exposing the mortgage fraud of a $500,000 home worth $93 million. Ladies and gentlemen, agencies are here to protect us. They're here to railroad us, along with the Bar Association.
All right, we gotta step off. I apologize, Rod.
All right.
I thank you, sir. All right. Rod's got a plethora of information. He's a good guy, and there's a mountain that can be had through him. Brian, I'm gonna try not to tear you up. Brian K., you're next in line, sir.
A happy day. Am I on?
Yes, sir.
Please, thank you. I'll just get right to this. I was taught to tell the truth, and it's such a fond memory of my growing up that I enjoy telling the truth. This goes so far as to think that other people enjoy telling the truth also. After all, telling the truth is part of survival. Did I drink water today? Is it safe to cross the street? Did that really happen? For many people, telling the truth is in the work description, as in the oath of office, and in court, swearing to tell the truth, the whole truth, and nothing but the truth. This is our history. This is the written record of what happened. We have the First Amendment responsibility to speak at this and other meetings to report what we see and experience so our leaders can know what is happening and make informed decisions. This is a God-given right and a golden moment in time. Under the First Amendment, there is no room for retaliation, escalation, or any attempt to silence or prevent any person from speaking at these meetings. When I approached our leaders with petitions and supporting evidence, they simply lied and submitted false documents, going so far as to forge my signature to no fewer than 4 false criminal plea agreements, doing so to meet the administrative requirements to win in court against me. This is a short list of the leaders who've accepted and continued the lies and the perjury. Orange County Supervisor Katrina Foley, her friend Anaheim Mayor Ashley Aiken, Anaheim City Councilwoman Natalie Rubicalva, Orange County Supervisors Doug Chafee, Don Wagner, Vincent Sarmiento, Janet Nguyen, Andrew Doe, Michelle Steele, Orange County District Attorney Honorable Todd Spitzer, DDAs William Ha, Alexander Shaban, Heather Monacy, Public Defenders or Public Criminal Defense Attorneys Alan Carvaro, Renee Garcia, Gassiep Garian, and Senators Dr. Stephen Choi, Tom Umberg, Congressman Lou Correa, and Assembly members Avelino Valencia and Sharon Quirk-Sylvia. Orange County judges Andre Mansourian, Gassiep Garian, Kevin Haskins, John Zitney, Craig Robinson, and Anaheim Police Officer Michael Kuna. For the most part, these officers remain silent about why they did and what they did for the perjury. However, the public record CA form 460 shows that Alice Apgarian, a dependent adult relative living with Gassiep Garian, is making contributions to the campaign fund for Katrina Foley, which violates canon number 5. An Anaheim police officer, Michael Kuna, when asked if he knows if a person can be Polish and Jewish, responds with both the N-word. So while painful, this is a very distilled report of the experiences faced in Orange County courts. And for those who petitioned redress of grievance, there's no redress. There's only more perjury. Please, I invite the higher level of leadership to demonstrate a higher standard. Under the Constitution, a violation of the Constitution is damage. And the only remedy is a correction to the record via acceptance of the petitions and redress of grievance. Please, thank you for the opportunity to speak. A happy day.
I thank you, sir. Next in line will be Lena from California. Go ahead and take it, ma'am.
Okay, my name is Lena Hannunen, and this is my testimony. I'm a graphic designer and an artist with 30 years of professional experience. That background gave me the forensic eye to identify what was done to me, and I'm here to tell you what happened and to present evidence that support every word. The injury began with the trap. My loan servicers, Specialized Loan Servicing, refused to send me a loan modification application unless I was 90 days in default. I had never missed a payment. To apply for help, I was required to become delinquent first. I complied with their instructions. The default they demanded became the weapon used against me. Forged instruments were recorded against my property in Julian, California. First was the deed of trust, notarized by Shane Thomas Case. I never met the notary who notarized my deed. His notary journal doesn't exist, confirmed by the Orange County Recorder. The second one is the assignment deed of trust, bearing the signature of notary Alton Carnegie of VisionNet System in Pennsylvania. Forensic document examiner Beth Chrisman testified at the trial that the signature was forged. The third one is a substitution of trustee, bearing the signature of notary Agnes Bradshaw of Colorado. At my trial, Ms. Bradshaw testified under oath that the signature was not hers, that her supervisors had access to her notary stamp without her presence. I have documented 75 forged instruments across 9 California counties with these same forged notary signatures, and I am attaching that evidence to this statement. I filed complaints with California Attorney General, the CFPB, the OCC, the DFBI, the DA's office, the FBI. I filed a police report and identity theft report. Nobody investigated. The fraud continued. I was a pro se litigant for 7 years and hired an attorney for trial, Dwayne Falk. He was disbarred on August 9, 2025, right after my trial. I had inadequate counsel during the most critical period of this litigation. During deliberations, juror number 5 submitted a written question to the court, whether a forged notarization invalidates the documents under California law. The question was never answered. The judge accepted the verdict without responding to the jury's question. After numerous motions trying to remedy the jury trial, the court amended the judgment and granted me UCL violations and cancellation of instruments, which proved that there was forgery, but the cancellation instruments did not specify which instruments were canceled, so it was no good. The judge stated on the record that forgery evidence was compelling and uncontroverted. She found forgery by the defendant, U.S. Bank, but the bank kept the house, and all my belongings were stolen. I have 2 appeals pending right now. I'm here because what was done to me was a crime. The record proves it, and somebody with authority needs to act on what's on the record. Obviously, numerous additional criminal players exist in this case, but no real party of interest ever existed. I have written a book called At the Helm, an artist fight that exposed foreclosure built on forgery that documents the case and has more of the details. Thank you for your time.
Thank you, ma'am. I appreciate that. Next in line will be Mr. Herms. You ready to go, sir?
Absolutely.
Take it away.
So my name's Louis Herms, former gubernatorial candidate in the state of California for 2026, and I bear witness to the following. Now, I will be using questions as I believe it will bring light to the ongoing violations of the electorate and humanity in general. Some of these may seem vague, but you'll see the connection quickly. So how is it in the greatest country in the world, we're eating food with up to 4,000 more chemicals in them than what we see in European countries? You cannot intentionally poison our people. If you list the poisons on the label, which is not done, and in its entirety, it's still a problem. How is it that our skies are poisoned daily? Several states have outlawed geoengineering of our weather already. Lee Zeldin has even admitted of the EPA that there's an issue, yet the damage continues to be done daily inside of our states. How can young men pretend to be girls and therefore dominate girls in other sports, use their restrooms, and be sanctioned to sexually abuse girls in wrestling matches while our political class stand by and praise this abuse? How in the great state of California that a judge has the power to force a minor to be forced to chemically try and alter their God-given anatomy based on the delusional request of one custodial parent? Why is CPS and DCS able to abduct children from their legal and lawful parents with limited reasoning, which happens to put over $100,000 into the system, yet it is proven that only $2,500 would keep a child in their home and remedy the situation that brought this to the courts in the first place? How is it that Big Pharma and APAC seem to have more control over the political class than the people do? How can large pharmaceutical companies get immunity from prosecution when they are knowingly poisoning people for profit? During COVID, the medical apparatus were incentivized for every step of the COVID process, which only ensured one outcome, a false narrative. The conspiracy is documented, as 3 prominent dictionaries in 2009 actually changed the definition of pandemic from people dying in the streets to whatever a 3-letter agency will dictate that it is. This was definitely planned. People know this. My mother had a lifetime heart condition, which put her in the care of a prominent cardiologist for several decades. This doctor told the entire family in a meeting before she had a pig valve installed that mom had the cleanest blood he had ever seen. And the good news is that she will never have a blood clot. Soon after, mom took the COVID vaccine and 2 boosters and shortly died in the hospital with a diagnosis of massive blood clots throughout her system. How is it that our First Amendment is being completely trampled on while the political class stand by and do nothing? My wife and I were at January 6th. We were actually on tape saving lives. We never entered the Capitol. Yet we were surveilled, put on watch lists, abused by TSA, and targeted by the FBI at and in our home for almost 2 years. How is it that I've been ranked as the #1 target on the Southern Poverty Law Center website, who has between a 0.5 billion and 1.5 billion just to attack Freedom Lumbers? Why are they not classified as a terrorist organization at this point? Why are our representatives completely silent on this massive intrusion into my First Amendment rights? Lastly, my investigations over years into child sex slavery are heartbreaking. How is child sex slavery one of the most profitable and fastest growing industries, yes, industries, in the United States, but they're going completely unchecked? How is it that many representatives that would never be reelected based on their poor performance are not only reelected, but hold office for several decades and increase their net worth as much as 50 to 100 times while holding office? The answer to all of the above are fake elections. For at least 40 years, we have lived under the illusion of choice that we're actually in a fair and free election process when we are not. We're in a systemized selection process, which has enabled all the atrocities previously mentioned to go unchecked. In California, as a candidate for governor in 2026 primary, I have a unique ability to pull records that others cannot. The findings are dramatic. We have found in LA County alone, there's 690,000 UAA, which is undeliverable as address ballots. 690,000. That's 11.8% when the average is under 2%. Yet, out of those 690,000, somehow 130,000 of those people that had an undeliverable ballot actually voted. We continue to do our investigation. We have several FOIA requests. We are under what's called a FOIA stall right now because they've decided to stall. They got past their certification and they're trying to do everything they can to prevent the evidence from coming out. We are working on it in full elections. We have the documentation if you need it. This fake system has helped propped up a media apparatus, liberal and conservative, by the way, that is 100% controlled by the CIA and the senior executive services. It is built for division. It is made to divide and conquer, to keep us focused on things that keep us distracted from the bubble of the illusion that we live under. Our government and political apparatus must be completely reset. Remedy must be made immediately because people have been pushed to the absolute edge of the cliff. I can tell you, we the people won't be jumping off that cliff. We will push back with every constitutional apparatus we have on hand, and we will be victorious, no longer the victims. My name's Louis Herms. God bless you, and thank you for hearing my testimony.
Amen to that, brother. All right. Mr. J.J. Humphreys, are you there, sir? I don't see you sitting amongst your cathedral. Oh, J.J. All right. Take it away, sir. You got to unmute yourself. Unmute yourself.
Hey, Carl.
Young men pretend to be girls and therefore dominate girls in other sports. Use their restrooms.
Okay, you got me?
Yep. Take it away.
Okay, you ready?
As ready as we're going to be.
Okay, so this is J.J. Humphrey. I am a state rep for the state of Oklahoma. I have listened to a lot of people today, and I can give testimony to about everything that I've heard to many of these people, whether it be guardianship, abuse of probates, medical, kidnapping, all of these. I've got hundreds, if not thousands of cases. But what I'm going to talk to you today about is we're going to talk about wrongful convictions. I'm going to give you 3 of those. I do want to say that I have a background in law enforcement. So I was a law enforcement officer, state law enforcement officer, 28 years. I've been a legislator, state representative here in Oklahoma for the past 10 years. And in that time, I've had these 3 cases that I'm going to give you as the most important cases that I've worked on. You can look up Richard Glossop versus State. This is a guy that was on death row for 28 years, roughly. Was on the gurney 3 times within 2 seconds of being executed. They stopped it due to a wrong medication in there. Numerous last meals, I believe 9 last meals. We have gotten actual proof. We were able to overturn this case in the Supreme Court, the U.S. Supreme Court, due to the fact that we got a signed sworn statement from the DA investigator who testified in a sworn statement that he was instructed by the district attorney to destroy 10 key pieces of evidence that would have cleared this gentleman. And this guy was in prison 28 years on the gurney 3 times because they destroyed that evidence. We also received or recovered a letter written by the DAs to the witness who we know was the murderer, the actual murderer. And it was written to the witness who was given a plea agreement to testify against this guy, and the statements encouraged him to commit perjury. They said that his testimony didn't line up with the medical examiners, and that they wanted him to change his testimony to help their case. Wrote out in the column what they wanted him to say. Guys, that's about 5 things that I've just named are felony crimes that the DAs used to try to execute this guy. We were able to prove that in court. The AG refused to file charges against these persecutors, I like to call them. But anyways, we have abundant evidence that this guy was able to overturn in Supreme Court, but now we're having to go back and have a new trial. So we're working on that right now. I want to give you another case, Tremaine Wood versus Oklahoma. This is another death penalty case in which we were able to prove that the district attorneys went in and had a person basically cleared, expunged their record. This person had a horrific stuff on their record. They went in and expunged that record so that person could be used to testify against Tremaine Wood. They knew that this was perjury on the court, and they went ahead and committed perjury on the court, then brought that person in and committed more perjury on the court by presenting this witness as a person that they knew had a record, but they had lied and said was not have a record. So again, we were able to get this man clemency because of the corruption. And in that, we caught the AG having conversations. So the AG knows about all of this corruption in the court, but yet the AG wrote the appellate court judge, the person over this death penalty case, to look at it. And again, he wrote him and said, move on, just go ahead and move on with the case. Now that's called ex parte. Both of them the judge should be removed. The AG should have been disbarred. Again, they should have probably both been looked at for criminal charges, I think. But at the end of the day, we caught them doing that. We were able to get this man clemency, but yet this is going on all of the time. We have these cases like this all the time. I could bring you multiple cases like this. The last one I want to talk about is in DHS. Guys, I can give you Department of Corrections. I can give you the court. I can give you DOC all day long. I'm really going through these fast. You can look up Richard Glossop versus State. You can look up Tremaine Wood versus State. You can get all the details. We've won all of those. This last case we're working on right now, we have a grand jury in Payne County, Oklahoma, that we're working on rapes. We're working on DHS fraud, all of this. But the guy that was over that had an abuse case on his child. He's the main organizer of the grand jury. They came in, the judges got together, collaborated with DAs and attorneys, and got this guy arrested on a false arrest. We can now prove 100% falsely arrested him for trying to protect his son, for being an organizer of a grand jury. They put $1 million bond. They've never had $1 million bond on that county, I don't think. They put $1 million bond. By law, on the charges they charge him, they can only set $10,000 if I know the law very well. And they said $1 million, then told him if he'd give his kid back, who they placed in a shelter, if he'd give his kid back, that they would reduce the bond $250,000. That's extortion, false arrest, extortion. They took his kid out of shelter, which again is under the AG's office, and they it's illegal what they did. They threatened the mother to tell him where he is. They gave the kid back to the abuser. The stepmother is who they threatened. Gave the kid back to the abuser. All of these are crimes that the police, the judges, all of them committed. The AG is over that shelter. So his duty to make sure that these crimes are prosecuted, and he has failed to prosecute. So guys, we've got a major grand jury. We're able to prove that, like one rape case where the guy is on video, has admitted to raping 2 women, strangling them. The judge goes in, is supposed to accept. He pled out to like a 77-year penitentiary time, and the judge went in and gave him 150 hours of community service. We have multiple cases. where ADAs were caught, assistant district attorneys caught with 150 hours of porn, 150 videos of porn, and yet they failed to prosecute them until we come in working on the grand jury. So I've got all kinds of cases like that. Again, I got many of these probate cases, many of DHS fraud, rapes going on in prison. I could go all day, but those are my top three that I'm working on right now. We're still actively involved in the Glossop case with the new trial. So those are the top three I'm working on today. If you got any questions, I'd be happy to answer. That's a lot to pour down on you.
All right, I appreciate you, sir.
Yes, sir.
Always good.
Y'all have good.
We've got. Go ahead.
Kathleen?
Go ahead, Kathleen.
Yep, I'm up. Okay. So 1982, my 4-year-old son was kidnapped across state lines. I had full custody and 8 restraining orders. They wouldn't, the Pennsylvania state would not honor them. Nobody up to the governor. And then they say, go back to Ohio. I go back to Ohio and the prosecutor wouldn't, we don't prosecute kidnapping across state lines anymore. You have to go back to family court. So that prosecutor and that judge, Prosecutor Forshoni in Stark County, Ohio, and Judge Hoffman of the Municipal Court in Stark County, Ohio, I found my answers. I studied the Constitution with groups of people who had lost their farms to IRS for not filing Social Security disability in their income tax forms. They didn't know it was necessary till they got their farm taken. So what I realized, the grand jury is the only way for the people to get remedy from the government. The government has become incorporated, and a corporation has to make profit. They're not there for justice, and you can tell because there's a lawsuit that none of them up to and including Biden's cabinet have ever had an oath or a bond in our generations, the last 3 generations. They feel now they're teaching the new attorneys that LLCs are your immunities. Protect yourself and do what you can in our ball field. So when I studied the grand jury, by the time I realized what had happened, why can't I protect my son? I had been at the law library upstairs. I found my answer. Yes, I can have a grand jury. I come down to the Judge Hoffman's chambers to tell him, yes, I can have a grand jury. I hear the prosecutor Forshoni telling him, she's up there in the law library studying the grand jury. What are we going to do about it? So I didn't go in, needless to say, because I heard him say, give her something else to think about. So I go back to the law library at 4:30 in the afternoon, like clockwork for the last year. I come out of there, and the Common Pleas Judge Haas, Stark County Common Pleas Judge Haas, his son-in-law ran 2 red lights at the square to T-bone me in my tiny little car with his great big boat. I stopped just in time because I saw him coming in front of me. I didn't even dent. I scratched his fender. I was found not guilty in traffic court. He sued me in his father-in-law's court that 1 week out of back surgery. Nobody showed up. I said, you got to dismiss it. He says, oh, we'll give him another chance and call him back. Next Wednesday, we show up. The attorney for his son-in-law spoke. The judge slammed the mallet and said, I'm guilty for $7,000. And I said, Your Honor, you say one more word, you're going straight to jail. And I'm still on Percocet from my back surgery. So I wasn't qualified to argue. So they changed my kidnapping into the problem of no driver's license for the next 15, 20 years until so they broke my neck, broke my back 2 separate times. That first crash was the one I just told you about. The next week they arrested me. This is 1990. They arrested me, put me in jail. 5 deputies beat me bloody, and 5 other deputies held me down, put a needle in my arm. And I was there until Monday, from Friday till Monday, where the judge said, how do you plead to these charges? I said, well, you see, I need medical attention. I'm bloody. He laughed. How do you plead to these charges? I said, well, then I'm innocent and I need a jury. He says, put this girl back in jail till she'll cooperate without the jury. So they did. And within the next 10 years, I was arrested 14 times, each on the weekends. Once I was there for 30 days. And by 1990, they had gang stalked me enough that they pulled me out of my friend's truck in a blizzard, broke my neck and my back. I've got steel plate and 6 screws. And they, enough of my, I could go on. The fact is, they don't have oaths of office. They're not bonded. They're obligated to have oaths of office to hold our public offices. The corporation has taken liberties that they don't have authority to take. And unless we continue this conversation as a First Amendment assembled body of knowledgeable people and bring these consequences, we have all of these names that we're just listening to. When we put those names on the list and start processing them, the executive order 13818 that Trump signed 2017 in part says all public servants found corrupt are to have their properties, assets, and accounts frozen sooner rather than later because they tend to hide what they've stolen. That is our remedy of protection. When we start providing lawful, peaceful consequences by serving them notice of liability that they've already received many times from many different places, we start processing these names one at a time, and the consequences will bring them back online to recognize what their duty is. Due process is their only duty, and they've failed. So now our due process is to come together in agreement and vote each case by case. At the county level is where the damage happens. At the county level is where we find our remedy. Those people in Congress are not wanting to punish each other. They're all guilty. So if we don't bring it from the grassroots with toll and roll and continue this conversation, we are the problem. Thank you. I yield.
Perfect. Thank you, ma'am. I appreciate that. All right, that's just about the end of it. We've got watchers that are going to each give us a bit of their information. We're going to start off with the Chief Tomahawk there. I dig your hat and your background, sir. I appreciate your service. Go ahead and take it away. You'll have to unmute yourself. Perfect.
Thank you very much. Number one, how many people have actually had a chance to go and research law? That's number one. The problem in America right now is most people don't read. My speech is a little way because I'm just getting over a stroke also. But most people don't take the time to educate themselves and read the law. But they want to argue the law in a court that they really don't have to be in a court. Everybody that goes to court right now that I know of is treated like a corporation. They're not going after your body, they're going after the corporation. But you have to understand, the United States corporation in the capital letters is not valid anymore. How many people really know that? Most of your officers that are on the street aren't educated in law. They're educated on statutes, codes, and ordinances. They don't have time to go and take a law course. And that's why they get away with everything. The people are actually the government. The government that you're writing and complaining to is not government. They're all imposters. And until you realize the people have more voice than the people that you're paying to speak on your behalf, you're going to be stuck in the same loop you're involved in now. If anybody has any questions for me?
I may.
Yes, ma'am. Go ahead.
So you say we don't have a constitution anymore, but I beg to differ. Our republic, the constitution is in our hearts, right?
All right.
Okay.
Those guys are.
I apologize. We're not going to get into debates right here in this session. All right. We're not going to get there.
I'm not trying to debate, or I'm trying to give a.
Yep. Nope. That's fine. What we'll do is I've got 0 questions for you at the moment, Mr. Tomahawk. So we're going to step off to Mr. Mack. Take it away, Mr. Mack. You'll have to unmute.
You're live.
Yep.
Okay.
Go ahead.
Okay, you can hear me now?
Yes.
Yes, sir.
Okay. Folks, it's been a long morning, and there was a lot said. There's no question that the abuses go on. That's happened personally in my own family, and I'm not going to go into that story, but it's happened. We've all been abused. There's so many victims of corrupt government. If these people get bonded and sign their oaths, they're not going to be any more honest then than they are when they raise their right arm and swear the oath, as I did and as Sheriff Darleaf has done. I've still got lots of questions about this. I have another meeting in 2 minutes. So I would say that I'm wondering where we're going with all of this. Are we filing this? Is a grand jury hearing this and going to file some writs? Uh, I don't believe that the citizen grand jury movement has gotten any traction nationwide at this point. It needs to get it. But I also believe there's a real political chance of just going to the county commissioners and having them make an ordinance that the county attorney and prosecutors within the county must be fair and honest in their grand juries, how they're managed. Because the biggest problem is that the accused person or the defendant is never allowed to present evidence before a grand jury. Only the county attorney is. Only the prosecutor is. That's the biggest corruption of the whole system right there. I think would be better off spending time uh, showing the problem to the county attorney or showing the problem to the county commissioners and showing that the county attorney is the one that has bastardized and ruined the grand jury system. I think it can be done fairly where the people are back in charge of most of it. But I think the easiest remedy is going there. But I still don't know for sure where all of your plans are in going this. I would like Billy or someone to respond to me and Sheriff Leaf in
Yep.
what goes on now. Where are you taking this, and what was the intent of having this meeting today?
Yes, that'll definitely be coming out. We've got to glue all of this together. We've got to give them a response rebuttal time, and then we're going to glue it the rest of the way, and we'll be on to that next step. So we'll be in touch for sure.
Okay. Well, thanks. I've got to leave. I've got this interview I've got to do, and this was supposed to be 4 hours, and I've been doing this ever since 4:30 my time, and
Yep.
it's now 10 to 10, so well over time. But I think it was
Yeah, we appreciate your patience,
worth
sir.
it. It's worth it. This is what I do full time, is to try to restore the rule of law and the Constitution and protect people. And so, thanks for having me, and I'll turn it back to you.
Thank
All
you.
right.
Stay
Thank
blessed.
you. Have a good day.
Thanks.
Kathleen, I'll ask you to mute for now only because there's something in your background. If you can do that, please. And then Sheriff Dar, if you don't already know, in order to unmute yourself on a phone, you've got to go *6, and that should unmute you. And you're next. There we go.
All right, there I am.
Yes, sir. Go for it. Yep.
Yeah, I was just kind of wondering, like, Mac, what direction are we going with this? There's an awful lot of information in there for me to absorb. And
yes, any of us.
Oh yeah, I had no idea. This, I don't know how many hours you spent on this. I was going to hear this much testimony. I'm just taken back. I don't know what to say. Part of my problem is the just from my dealings is the dealing with the bar, the state bar, the federal bar. It's almost like dealing with a Teamsters union, and how Teamsters will protect Teamsters. They seem to protect each other. They don't want a civilian. We've been trying to get our legislature to do a civilian watchdog over them because they're supposedly licensed, but they're not licensed to our state. They're licensed through the state Supreme Court, which that causes a problem because we have prosecutors, and they're claiming the prosecutors have to be licensed attorneys. Well, there's no licensing. It's all bar card. And, I put in a little talk text here that there's less than 1% of the population are attorneys, but they control over 90% of what we do. And to me, that's one of the biggest problems I see.
Right.
In other words, they're not going to let you play in their sandbox.
Correct.
They don't want the average citizen. They don't want the average citizen playing in their sandbox.
Correct. With you as a constitutional sheriff doing your job proper, and Sheriff Mack out there doing his job, and I feel we need more all the way across the nation. We need the constitutional sheriff to educate the sheriffs. When I lost my house, I asked my sheriff to read their oath of office because it was a constitutional oath of office, but they don't teach any of that anymore. And
no,
I had 12 officers at my house to walk me off my property, and I tried to educate them as they were stealing my property. And someday I hope they get that education, but they're not getting it. So I give you kudos for being that guy, and you're still in office. So educate, educate, educate. As far as the bar card holders, I think that's our ultimate. I'm sorry.
The problem is every 4 years you got to educate a new sheriff. Same thing with your commissioners, your state representatives, and so on. There's no term limits in Michigan for sheriffs, but they retire. You got to retrain new sheriffs, and that's for Sheriff Mack. It's almost like he's a dog chasing tails trying to keep these sheriffs educated on this. When we get them educated, we are successful. When I see them standing up to like the Virginia governor and their ridiculous gun control, we go through some very rigorous training on how that Constitution is supposed to work. Like, I'm very familiar with the fact that it's supposed to limit government, not the people. And now what do we have? We have them going, well, you guys can't have these assault weapons. Well, define an assault weapon, because that definition will change in 5 years, and they'll take more and more. So it's the constant training. We have to get the constant funding. The courts, again, they're part of that bar, and that's what I see is that if you're not an attorney, they're not as likely to listen to you.
Copy. All right. Well, I thank you for your time. I appreciate that, sir. And we'll be circling back around to you for sure. Probably come from Billy. With that, I think Michelle's got a closing statement, and I believe we'll be done. It's been a morning.
I got one more question.
Go ahead.
How can we get this information you guys hear? How can we get this down to our schools, our public schools and our colleges? I think when we start hammering away there, when people realize that, oh my goodness, I've got all these rights, and they've been kind of, excuse my expression here, but they've been pissed on all these years. So how can we get these kids all educated to take it back?
That's a hard question. And what I'll say to that right now is one set of boots at a time. Every one of us has to go out into our communities and stomp and educate. And that's the only way we're going to get it done, I believe. And I'm right there with you.
All right. All right. Thanks for having me.
Thanks, sir. All right. You ready to go, Michelle?
As stated in the previous proceedings above, we are endowed by our Creator with unalienable rights, life, liberty, and pursuit of happiness. The individual, the nefesh, the living soul, sentient mind, and breathing creature possess three sacred, inseparable guarantees. To give a man his life and deny him his liberty is to provide a cage. To provide liberty, but strip the property that is the fruit of his labor, is to maintain him in servitude, and we reject this. Should this be the people grand jury find probable cause supporting the allegations, the mandated remedy is the former issuance of a presentment of findings declaring the following: nullifications by a fraud. Fraud mediates every transaction, any administrative, statutory, or judicial presumptions binding the sovereignty of the living is inherently fraudulent and void upon rejection by the injured party. Ceasing of claims, an immediate command to cease all algorithms, policies, and tracking mechanisms attempting to assert commercial utility over spiritual or digital soul of the populace. Mediation of contracts. Any contract lacking fully informed voluntary consent is invalid. We hold the two-step conversion of a private right into a surety for corporate fictions as an act of criminal deception. Declaration of agency. Pursuant to 28 U.S.C. 3002, the United States is a federal municipal corporation. Public servants are agents of a foreign principal. Any attempt to convert private rights into public franchise without explicit written informed consent constitutes unlawful conversion. Nullification of unconstitutional acts. Per Norton versus Shelby County, an unconstitutional act is not law. It's unoperative and void, affording no protections to those who enforce it. Breach of fiduciary duty. Public officers are trustees of the people. Actions taken to undermine individual rights or guarantees for personal or agency gain are a breach of oath and public policy. Enforcement of oath and bonds. The oath of office is a binding contract. Failure to exhibit a valid bond or operate without constitutional bounds is grounds for immediate ouster. Unlawful conversion of labor. The taxation of private labor through third-party reports absent a voluntary franchise constitute involuntary servitude in violation of the 13th Amendment. Schedule of liabilities. Pursuant to 18 U.S.C. 3571, public servants acting under color of law face personal, commercial, and criminal liability for each violation of rights ranging from $2,000 to $250,000 per count. The administrative justice system has systematically coerced this population through fear. As we hear, many of you have given testimony today. You are very brave, but overall, people are doing this through fear. Artificial presumptions and the subversion of natural rights. Upon receipt of this notice, all parties are granted a strict 7-day grace period to come into absolutely constitutional and lawful compliance. Rebuttal clause. Should any party contest the findings or the jurisdiction asserted herein, they are formally invited to submit a verified rebuttal. To be considered valid, any such rebuttal must meet the following criteria. Verified physical evidence. Rebuttals must be submitted in form of a sworn affidavit, signed in wet ink by a human agent acting with full personal liability. No unsigned documents, computer-generated notices, or policy statements will be accepted as evidence. Proof of lawful nexus. The responding party must produce a specific organic law or verified contract signed by the living party that grants the administrative entity jurisdiction over the nefesh, the living soul. Demonstration of authority. Any rebuttal must explicitly demonstrate how the challenged action complies with the organic Constitution and the Articles of Confederation. General citations to administrative code or standard operating procedure will be rejected as non-responsive. We invoke the universal maxim of law. He who is silent is understood to consent. Failure to provide a verified rebuttal signed under penalty of perjury by a competent living agent of the responding entity within a 7-day grace period shall be deemed an admission of all facts stated herein and in tacit agreement to the claims of fraud, breach of trust, and lack of jurisdiction. Your silence is not defense. It is a confession. By failing to respond with verified evidence, you waive any claim to immunity. You abandon any defense of your actions, and you forfeit any rights to contest the findings of this grand jury. The record will be closed. The findings will be entered as an indictment of fact, and the process of collection and ouster will commence immediately upon the expiration of this notice. Failure to cure. Failure to produce this verified evidence within 7 days of receipt shall constitute a confession of fact and a tacit admission that no lawful jurisdiction exists. Such failure result in the immediate issuance of presentment of findings, triggering full personal, commercial, and criminal liability, including immediate proceedings in the filing of liens for damages without further warning or notice. Following the presentation of all the testimonies, the jury will receive instructions with the instructions for the 7-day wait. The strict enforced 7-day rebuttal window begins at the close of the final testimony at the end of this. The accused parties are permitted to submit verified physical wet ink evidence. No hearsay, no algorithmic assessments, and no policy manuals will be accepted. The jury will stand down during this 7-day period to allow for the review of all submissions. If no valid verified evidence is produced, the jury's findings shall be considered conclusive and entered into the permanent record. As we conclude this assembly, we stand at a new dawn. Today, July the 1st, is the day the bell is torn. Many of you may not know that July the 1st was when the first vote and discussion for the Declaration of Independence, as well as when they activated zip codes, and another day, it was on July the 1st. We acknowledge the weight of 250 years. An empire built on the illusion of consent is now collapsing under the terminal arrogance of its own overreach. The dream is over. The theater of shadows and debt is being dismantled, and the actors are being stripped of their mask. Do not mistake our restraint for weakness. We have documented the blood spilled in your wars, the assault on our biology, and the trafficking of our offspring. We see the hidden hand. Every breach of oath and every act of violence is now a permanent, unshakable liability against you in every realm, physical and spiritual. The final restoration, we stand as one with the Creator, the ultimate judge of all existence. We forgive the transgressions against our spirits, but we demand full and absolute accountability in the physical realm. The scrolls are open and the accounts are being settled. The white horse of truth is already in motion. The era of concealment is over and the era of restoration has begun. We demand the immediate restoration of all stolen agency, the trafficking of our offspring, labor, and property across all realms. We demand that all scales of justice be balanced by the hand of the Creator's law, not the fraud of corporate statute. We demand the truth to be revealed in every quarter of power, for there is nothing hidden that shall not be uncovered, and nothing secret that shall not be made known. The sleepers have awakened. The machinery of your control is grinding to a halt. We do not ask for a return to the old ways. We call for an absolute restoration of the natural order. The sovereignty of the living is final, is no longer yours to infringe. We know that you made bets, but you made a bet on the wrong event. You should have bet on the people, because today we won, and we will continue to win. The record is closed. The judgment has begun. The horse is in motion. So it is written, so it shall be. And I turn it back over to you, John.
All right. Thank you, ma'am. With that, I'm going to give final recognition to all the folks that came in for testimony, our watchers, our jurors, and we're going to end it with a gavel and a knock on the wood. With that, we'll conclude.
Ready for the fireworks?
Take it away, sir.
Stay blessed.